Good morning, everyone. The time is 9 o'clock. I hereby call this Citrus County Code Compliance hearing to order. And so normally at these hearings, we follow an agenda. The first item on the agenda is the call to order. The second item on the agenda is the pledge to the flag. So I'd like to ask you to join me as you're able to stand for the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record should include the testimony and evidence upon which the appeal is to be based.
Okay. So the next item on the agenda is the minutes from the Wednesday, October 15th, 2025 hearing. Are there any proposed revisions, deletions, changes, or otherwise to the minutes as currently formulated? Hearing none, I'll go ahead and approve them. Okay. Staff update? Okay. All right, the next item is I'll give you a brief opening statement. Good morning, my name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over this hearing, your hearing. What I'm going to tell you during this opening statement applies to all of your hearings, so I would ask that you pay attention. When your case is called, I will ask you to come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call its case and I will allow the county to first present its case. The reason for that is I don't know what's going on until I've heard from the county first regarding what their case is. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case before me. Additionally, these hearings are transmitted over YouTube, so keep that in mind. I will also ask whether or not you are contesting the violation. If you do not contest the violation, I'll assume that there is a factual basis for the case and that I'll just ask you how much time you need to fix the violation or to work with the county. This will help save time for yourself and others. You are by no means required to do so. If you oppose the case or simply want to be heard, you have that right. When making rulings, I will factor in all kinds of things. I factor in how severe the violation is, the degree to which you've cooperated or been antagonistic, all kinds of different factors that I have in my discretion to consider. So sometimes it's in the party's interest to come to a resolution ahead of time. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that I give you a time to comply before a fine begins. You must fix the violation by that date, or a fine will accrue for each day that you remain in violation afterward. The law allows Citrus County to impose the accrued fine as a lien on all of your property. The county then has the right to foreclose on that lien or to seek money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who does have questions about their rights or remedies to seek legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate these into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs. Let's see. You do have the right to appeal any order I make today as provided by law. Thank you for your attention.
First case today, Michael R. Novich, case number 2025-1388, Code Officer J.C. Charlton, page 23 of your agenda.
Mr. Novich, if you would go over here. Good morning. Welcome. And will you state your name for the record?
J.C. Charlton.
Thank you. So I had continued this hearing from the last hearing. I don't know if there's anything either of you want to say before I get started, but the reason I continued it is that I think there was a snafu with, I think, arranging your presence, Mr. Or at least you knowing that you could come. So I didn't feel comfortable issuing an order without your ability to be heard. So this is case number, let me see if I have it, case number 25-1388. Mr. Charlton, is there anything else first that you want to say?
We conducted an inspection yesterday and property remains in violation.
It remains the way it was. Mr. Novich, is there anything you want to say before I issue an order?
I'm not sure what time he came by yesterday, but I believe it was yesterday as well as today that I've removed all of the beans from growing on the fence line. However, I did have some clarifying questions on the beans as I view their removal as something that I've optionally elected to do due to it being wintertime and the beans having fulfilled their role in the food forest. So the beans were always a temporary thing. I have photos that I actually took this morning showing the beans removal. So what I would like to clarify is under Florida law, as it stands, are homeowners required to retrieve debris from a neighbor's yard that their tree may have caused or created, such as leaves, acorns, or say a fallen branch?
So, Mr. Novich, I could answer that question, but the problem is that that's not, you'll have to forgive me, it's not relevant for the hearing today. I understand you may think it is. I think that you need to consult with your own legal counsel on that. I'll tell you as a general rule that long settled over hundreds of years, normally when something comes from a live tree over a property line, that is the obligation of the neighboring property owner to take care of. If it's a dead tree or something like that, that normally is the responsibility of the owner that has the dead plant. The issue with your case is that, I did find that there wasn't enough evidence to surmount your defense for most of it, regarding the Florida-friendly stuff. But my issue was the management of it to the extent that it went to the property line.
Okay. So this morning, I reached my hand over the fence line and grabbed beans like this. So you're seeing the trespass scenario that's being created. So I'm curious how that plays out and what the reasonable expectations are as one property owner to reach onto. Is trespass kind of applicable to my feet and not my hands? Where are we going with this?
I'm not going to get into a quantum mechanics debate of the law. Trust me, I'm not belittling. I think you have genuine questions. It's just not relevant for whether or not there's a violation on this case. So,
isn't the violation found in regards to the maintenance of those beans?
We'll get to that. So before I go further with Mr. Novich, is there anyone from the public who wants to be heard on this case? I don't see anyone. So Mr. Novich, what I'm going to do is I'm going to issue an order and see if you have questions. My intention was at the end of actually at the beginning of the last hearing is to issue an order, and I think I made clear what my order would be. You probably have seen the recording, but I find that the county didn't succeed in surmounting your defense regarding the Florida-friendly landscaping generally, but I did read the statute closely. I find that the county did prevail to the extent that it showed what I would consider improper management techniques under the statute that you quoted. just to the extent that if it affects a neighbor, if it grows along the fence, I don't think that that's covered by the protection of the statute. I do think the statute protects a lot of what you're doing, unless there's evidence that comes forward that says the landscaping you have isn't Florida friendly. Now, I didn't see any of that. I didn't hear any of that. The only evidence I had was that was your evidence. So I'm going to grant, I mean, you may have already fixed it, but I'm going to grant 14 days to bring it into compliance. And if it's not brought into compliance as ordered, I don't know what the county's recommendation was, but.
Is the order?
Hold on, Mr. Novich. What is the county's recommendation?
$50 a day.
I'm sorry?
$50 a day.
$50 a day, the lowest the county goes. I'm happy to hear from you.
Is that applicable to the beans? Or is the idea that we can't grow plants along a fence?
No, it's what is shown in Exhibit A of the evidence that is in the evidentiary record. So I think that if there are going to be questions, you need to keep in touch with the county, let them know when it's been abated, and they will tell you if it's been abated or not.
Okay. Am I able to leave with a copy of it, at least Exhibit A?
I am going, well, I think that's a public records request, and you can definitely talk, Mr. Charlton, I don't know how you guys handle that. Well, Ms. Harrison, I would construe that as a public records request.
Yes, that can be construed as a public records request. Does he want them mailed to him? How does he want them conveyed to him? Because
I'd like them to
Handle that with the county.
to me or just
You've heard the
told
county
to
will
me.
give it to you. I don't think they have it here today, but they have a duty under the public records law to comply, so you will get it.
Okay. And then just one kind of clarifying question. Plants are unique. They spread in different types of ways, not only from seed, but they will send underground runners and root suckers. Is this something where, you know, Florida native persimmon, which spreads and it's a tree, is, again, I guess I just don't know how I'm supposed to control nature.
It's above my pay grade, Mr. Novich. I'm not an expert in persimmons. I wish I was, I'll tell you.
They're
but-
tasty.
But I've heard stories about it. I'm a picky eater, so I don't get out much. But I think that's beyond the purview of this hearing, Mr. Novich. So I wish you luck.
Thank you.
Okay.
Appreciate it.
Thank you.
while JC is retaking his seat, Your Honor, I have been told we have 3 no contest cases this morning that Mr. Charlton will announce once he's able to
Call him up.
sit back down.
Mr. Novich, we have to continue with the hearing. I would just ask that y'all chat later.
You want to do the no contested?
I do, yeah.
Okay.
So we will call up the cases. I think it's the county's intention to call up the cases where a resolution has already been received. So if we have a resolution early, we'll just send you home. We'll get it announced on the record and you can go home. All right, thanks.
Next case, Colleen Marie Ashmore, case number 2025-1604, Code Officer Cody McGuire, page 5 of your agenda, expert on the case, Land Development Director Joanna Coutu.
Oh, boy.
I've been notified this is a no contest case. The parties have agreed to 90 days to cure and $50 a day thereafter if not brought into compliance.
Let's swear him in.
I do. Colleen Marie Ashmore.
Good morning, Ms. Ashmore. Did you hear the proposed resolution?
Yes, sir.
90 days, $50 a day if not brought into compliance?
Yes, sir.
What pets are we talking about?
Horses.
How many?
But I have about a dozen. I need to
Wow.
get
What's the
that
size of the property?
At least cut 3 acres. I need to cut them at least
Ooh.
in half.
That's rough.
That being said, some of them are small horses and some of them are bigger horses. I don't want this many animals. I'm not the
Right.
animal hoarder lady.
Hey, I love horses. It's just,
Too many's too
the
many.
code is
and
the
I'm in
code. I
com-
mean,
I'm
part of
in
the reason why the
complete
code
agreement.
exists for the animals is for the animals protection. I mean, 3 acres for 12 horses is not ideal.
That's not bad. I mean, they've got food in
Oh, I've
front of
seen
them
worse.
24/7.
I've
They
seen
all
worse.
look good.
Yeah.
They all, you know, it's not a hoarding situation. They're not in unsanitary
You're
conditions.
not eating them.
They're well cared for. Oh, heck no. But I am licensed as a trainer through the state of Florida. So in the process of rehoming them, and the reason why I've asked for the 90 days to try and get them, a bunch of these rehomed, is because if one of these animals that I rehome ends up at an auction where it could potentially go to slaughter, I will lose my license and be in a lot of trouble with the state of Florida. So it's kind of one of those, it's gonna take me a little bit of time to try and find them appropriate homes, which is what I've been doing.
Is 90 days sufficient for that?
Possibly.
I really hope so. I mean, they shouldn't end up at the slaughter.
I hope so.
Okay.
They absolutely cannot, and
Okay. All
they
right.
cannot.
Then I will adopt your proposed resolution and find that a violation exists, grant you 90 days to bring it into compliance from the date of my order, and then there would be a $50 a day fine if not brought into compliance
Yes,
as
sir.
ordered. Okay?
Thank you, sir.
Good luck.
Thank you.
I appreciate it.
Oh, I'm sorry.
Thank you.
Actually, is there anyone from the public who wants to be heard on this case? There is someone? Ma'am? Okay. Well, there you go. It's not a proper public comment because you're not putting your name on the record, but you've heard what you need to hear.
No, that's
So
great.
let's move this.
Anybody else want a horse?
Thank you, ma'am. I like it.
Thank
Okay.
you.
Next case, Darrell Martin Bergrano is Marie Palat Gonzalez. I apologize for the pronunciation.
That's the next case. Looks like
I was told-
Baragano and Gonzalez.
I had the wrong one. I apologize.
Page 6.
I apologize.
No, this is,
Next case, Austin A. Bronca and Lacey Provinger, case number 2025-1686, Code Officer Alan Jonason.
Well, I didn't know either, but
We're wheeling and dealing.
this should be relatively quick.
Okay. Okay. Let's. You can go ahead and swear her in.
I do.
I do.
Lacey Preventer.
Welcome.
Alan Jonason,
Good morning.
good morning.
Your Honor, I was notified by the code officer who's proposing 60 days to cure and $100 a day thereafter if Ms. Bronca is in.
Ms. Preventer.
Ms. Provencher, sorry, is in agreement.
Ms. Prevention, do you agree with that?
Yes, I do.
Okay. Can you just tell me, Mr. Johnson, can you tell me a little bit about what's going on?
Yes, sir. So there's some tree debris on the property. There's household trash, some things that were removed from a shed, just kind of sat out to the side. I've spoken with her and they've indicated that they've already started making progress. I have no doubt that it'll be finished in 60 days.
Okay. That's what's important to me. I don't want to set y'all up for failure. Is there anyone from the public who wants to be heard on this case? I don't see anyone. So, ma'am, I'll adopt the proposed resolution. You have 60 days from the date of my order to bring the property into compliance. It'll be $100 a day if not.
Okay,
All right, thank you.
Thank you, ma'am.
Next case, Timothy and Lindsay A. Fladd, case number 2025-1563, Code Officer Alan Jonason, page 12 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
I need time to cure and I'm out.
Timothy Flad.
Good morning, sir.
Good morning.
Your Honor, I've been notified that he is. No contest, but I do not have an amount of the fine or a time it would take to cure.
What's the county's recommendation?
Well, my recommendation is 90 days. They're in the process of getting the permits for the property and $100 a day.
Okay. Well, why don't you, Mr. Jonason, tell me a little bit about what the county's case is?
Sure. So this is a storage on a vacant case. There are multiple sheds and a dock on the property. Again, I've spoken with the property owner. They've started the process. They're waiting on their plans. I anticipate 90 days is more than enough time. to
Is
get
the dock also subject to this?
Yes, sir.
Okay. Does that sound about right, Mr. Flood?
Yes, sir.
Now, are you receiving or seeking permits for everything that's currently on the property?
We purchased the property with the sheds and the dock, and we are trying to get plans drawn for a residence on the property.
Gotcha. So is the hope that upon receiving a permit to build the residence, that everything will be okay?
Yes.
Ms. Katu, I don't want to set anyone up for failure.
No, and I appreciate that. Sorry, Joanna Coutu, Land Development, they do not have permits for the dock or the shed. They showed up around 2020 and 2022 without permits, so he will have to also permit those for this case.
But so in the process, so I just want to tease it out so that you and we're on the same page. By virtue of receiving a permit to build the residence, it will not solve the two things you just brought up.
Correct. It will allow him to apply for a permit for those two things, but not yet. And we
Which
don't
he
have-
can't do now because he
Right.
doesn't even have the,
And he's working on the plan, so we don't have an application yet even for the house. So I'm not sure if 90 days is going to be enough.
So that's the thing. So if he gets a permit for the residence, it will not abate the violation
Correct.
for the dock, for the other stuff. He can only begin the process at that point. I mean, 90 days is a stretch.
It is for an after-the-fact dock, yeah, that might take some time too, yeah. The sheds probably are simple, hopefully they're prefab, but.
Yeah, so the only question here is how much time? Because does this all make sense, what we're talking about?
Yeah, I didn't realize that the dock was unpermitted and the other shed, or the sheds weren't permitted. It's hard to say time frame because since probably the 1st of October, we've had plans in drafting. I have preliminary plans that he's drawn. But
How big is the residence going to be?
it's going to be a tiny house.
Okay.
360
Oh,
square
wow,
foot.
okay. I mean,
It's-
gosh, that shouldn't take too long to.
It's just a weekend. We have boats,
How big's the piece of property?
0.86 acres.
It's on water?
Yes, sir.
It's one lot, 0.38, and then he might own two lots.
Wow, okay. Well, we can't do 90 days, but it just shouldn't take that long for the permit review of a tiny home, right? I mean, I don't know if they're allowed. I don't even know if they're allowed in
We
this.
were told they weren't
Okay.
allowed.
What's the county's recommendation on a fine?
$100 a day.
$100 a day? Well, what I'm going to do is I will grant 150 days, given the circumstances. And if it's not brought into compliance, $100 a day. So you've got a couple things going on. It's not just the residential permit, it's the other stuff.
Yeah,
You're gonna have to start hustling.
we
Okay.
just found out about the dock.
Is there anyone from the public who wants to be heard on this case? All right, then that's gonna be my order. Good luck.
Thank you, sir.
Next case, Jason and Jennifer LaFrancois, case number 2025-1709, Code Officer Erica Olson, page 19 of your agenda.
Your Honor, I was notified this is no contest. They agreed to 7 days to cure and $50 a day thereafter.
Oh, yeah. I do. Yep.
I do.
Jason LaFrancois.
Erica Olson.
Good morning to you both. Mr. LaFrancois, did you hear accurately the proposed resolution between the parties?
I did, yeah.
Okay.
Yep.
And Ms. Olson, can you tell me a little bit about what's going on?
Yes, sir. It's a normal junk case. There was some building materials, some tools, and some tires outside. It really wasn't a lot when I went by there on Monday, so I definitely think that 7 days
So on a scale of
is
1 to
feasible.
10, it's not
On
above
your junk
5.
scale?
On the Christian law junk scale, it's not
On the
above
Christian law
5.
junk scale, I would say it's maybe a 1 or
Oh,
a 2.
then 7 days is enough.
Yeah.
Okay. Is there anyone from the public who wants to be heard on this case? All right, I'm not going to belabor it. I will adopt the proposed resolution. I'll grant 7 days to bring the property into compliance. If it's not brought into compliance as ordered, a fine of $50 a day.
You got it.
Thank you, sir.
Thank you. Just let me know.
Okay.
Next case,
Want me sooner, I will.
Okay.
Brandy DeYoung and Lily Mae Oliver, case number
Those are the only
2025.
resolutions?
This is the last one.
Oh, okay.
Yes. Case number 2025-1756, Code Officer Cody McGuire, page 24 of your agenda.
Your Honor, this is our last no contest case. I've been notified 60 days to cure and $50 a day thereafter.
I'm sorry, can you repeat that, Ms. Harrison?
60 days to cure and $50 a day thereafter.
Okay, thank you. All right.
Yes, ma'am. Brandy Oliver.
Good morning, Ms. Oliver. So do you hear the terms of the proposed resolution correctly?
Yes.
You agree to that?
Yes.
All right. Mr. McGuire, what's going on?
It's just our typical jump case. She had ran into some vehicle problems recently, which put her a little behind, but the 60 days, she should have it abated.
Okay, you don't have any concerns about that?
No, sir.
All right, is there anyone from the public who wants to be heard on this case? All right, ma'am, seems pretty routine to me. I'll adopt your proposed resolution, find that there's a violation, give you 60 days to bring the property into compliance. If it's not brought into compliance as ordered, $50 a day.
All right.
All right, thank you.
Thank you.
I'm just surprised in looking at some of these cases that those are the only resolutions. I don't know if people really. I have on my list for 2 more. Oh, okay, okay.
Benita Lynn Whitehill, case numbers 2025-1574 and 2025-1575. Code Officer Alan Jonason, page 37 and 38 of your agenda.
Both of them? Yes. Your Honor, on these 2 cases, I was just notified 60 days to cure on both of them and $100 a day thereafter on each.
Okay.
Yes. Benita Whitehill.
Good morning, Ms. Whitehill.
Good morning.
Did you hear the terms proposed by Ms. Harrison as the resolution?
No, ma'am.
She said that on the 2 cases, basically what the county and you have agreed to is that you would have 60 days in each case to bring the property into compliance. And that's what we call a junk case and also what we call, I guess, what I call an inoperable vehicle case. So you'd have 60 days to bring both of these into, no? You seem confused.
The inoperable vehicle was removed.
Okay, so it's your understanding that it's gone.
Yes, it was a
Okay.
Jeep.
Well, we'll talk to Mr. Jonason about that, but
Okay.
let's set that aside for a second. So on the remaining case, is 60 days in your mind enough to bring the property in compliance?
Yes, sir.
Okay. Mr. Jonason, what's your take on the vehicle case?
So the vehicle is an unlicensed vehicle.
Unlicensed
It's a
vehicle.
recreational vehicle. And again, I've spoken to her. She indicates that she has the tag, just hasn't affixed it to the license plate yet.
Okay, so
But-
60 days would be enough to fix that, right?
Yes.
All right, so that's what we're deciding here. I mean, I'm not setting you up for failure. So the idea would be that these 2 cases that you've got today, you'd have 60 days to fix them. Sounds like you could fix one of them in about 5 minutes.
That's correct.
Okay, so if you don't bring them into compliance, you'd have $100 a day on the, fine. But it sounds like this is enough time for you.
Yes.
All right, so have you agreed to those resolutions?
Yes, sir.
Okay. And this is just for the benefit of the other parties. One of the things that I consider is how long the case has been going. If I find that you've been on notice of a case for 3 months and haven't done anything and wait to come to the hearing and it's obviously guilty, that's not a good thing. I will take that into consideration when issuing the fine. So I appreciate the resolution. Mr. Jonas, have you heard anything different, or is my understanding correct of what to do here?
Yes, sir. They've made tremendous progress cleaning
Awesome.
up the property, and I have no problem with 60 days.
Okay. Does anyone from the public want to be heard on this? I don't see anyone. So, Ms. Whitehill, I will find that there's been a violation in each case, but grant you 60 days from the date of the order to fix both of them. And to the extent that either of them isn't brought into compliance within the 60 days, there would be a $100 a day fine. I encourage you to just go fix it as soon as possible.
Yes, sir.
Okay? Thank you.
Thank you.
Thank you.
Thank you, ma'am.
Thank you.
Next case, Duisburg Enterprise LLC, case number 2025-1586. Code Officer Cody McGuire, page 11 of your agenda. Expert on the case, Land Development Director Joanna Katu.
I do. My name is Robert Sammons. I'm the attorney for Duisburg Enterprises. Duisburg Enterprises is owned by Dr. Wade Foster, who bought the property to continue his war against skin cancer.
Mr. Salmon, why would you swear an oath to tell the truth, the whole truth, and nothing but the truth as a lawyer? I'm just, I'm
Yes.
joking, I'm joking. As well, I get to
Yes.
joke about that as
Yes.
a lawyer, so.
When in doubt, do what the magistrate
Okay, okay, well, I've learned the hard way not to tell judges what to do myself, so. All right, so,
The status of the matter is, the history of the matter is, Dr. Foster wants to build a medical office. He was trying to get his plans completed. The architect told him that he needed soil tests before he could complete the plans. So Dr. Foster did push the trees in order to conduct the soil test, destroying one specimen tree that will need to be mitigated, and that's in the plans. Trying to get the plans finalized with the architect took until yesterday, and yesterday the architect began the process of uploading the plans through the Acela system, and was on the help desk trying to get them loaded. I do have a sealed copy, a hard copy of all the plans.
well, my issue here is I haven't even heard from the county about what the county's case is. So you're providing a defense, but I don't actually know what the case is. So if you don't mind, Mr. McGuire, what's going on?
100%, he summarized it all up.
Okay, perfect. Saved you some time. But so we're here on an alleged violation of LDC 4002A. Okay, so at least that's what I have in my notes. Can you tell me from your perspective so it's just one specimen tree?
No,
Okay,
sir.
well then tell me what the county's case is.
So this property is 1.17 acres and it's zoned GNC MDR, and all the trees were removed.
Okay.
The roots were removed. It was lightly graded.
It was cleared.
Yes, sir.
Okay. Is that the county's, that there's basically been site work without any kind of?
Correct.
Okay. Well, that does seem pretty simple. It sounds like there was a reason for it, but there always is.
Yes.
So the issue from the county's perspective, and the reason why we have to have these hearings, is that there has to be a deterrent value to the law so that people don't all just do that without proper review. So what is the county seeking here?
The county's seeking a one-time fine of $15,000.
Does my authority go that high?
Yes, sir.
Is that the maximum of my authority?
Yes, sir.
I see. Does anyone from the public want to be heard on this case? I do, and we're going to talk a little bit about it. Ma'am, would you like to come up? Yeah.
And for the record, we still do have the exhibits that Mr. McGuire is going to need to put in.
Great. I'm not issuing an order. Ma'am, why don't you come on up, and I'd love to hear from you. Yeah, sir, if you don't mind. Yeah.
Hello.
Hey.
Yes, I do. Yes, my name is Angela Johnson, and I own the commercial property next to the property that this case is in reference to. I just wanted to share that around August 15th, a gentleman came into my business named Big John, very fitting name. He was a huge guy, and he had been hired by Mr. Wade to clear the property. There was no access to the property, curb access, and they were asking if they could enter my property to be able to bring equipment in. He explained that the easement would require 3 of my concrete parking curbs taken out, that the job would only be 3 or 4 days, and that they would replace them. I had no idea there was no permits pulled at this time, just for the record. I explained I was concerned about disruption to the business. Asked how long it'd take, he said a couple of days. The job continued for several weeks. A mess was left consistently in the parking lot. I reached out to Big John August 28th, 2 weeks later, to tell him my mailbox had been knocked down. I couldn't receive mail. He told me he was no longer handling the job and had referred me to a gentleman named Jason. I messaged
Little Jason, big Jason, just
I know,
Jason?
no little.
Just Jason?
I don't know.
Okay.
I messaged Jason and asked him about cleaning up the property. We're open for business every day, and it was truly left every day a mess. Jason did begin cleaning it, the front and the back. He apologized and said that he would replace my mailbox. A few days later, he did. On September 3rd, the property owner, Mr. Wade, called and said I needed to move stacks along my property of all the roofing tiles that were stacked there, that his tree guy was there and needed to take a tree down on my fence. I asked, did he have a survey done to establish a property line? He said no, that would take 2 to 3 weeks, and he didn't have time for that. I asked how could I move these immediately. He said hire a handyman. I don't know, figure it out. I reached out to a friend of mine who happens to be a county commissioner to find out my rights and if a survey had been done. They reached out to the county and found out nothing had been pulled. No permits, no surveys, nothing. So basically, to summarize it, the land was cleared, including many, many trees on my property. He assumed the fence on the property was my property line. It was not. It extends 3 to 4 feet beyond that. There were many live trees. Turtles always come on our property. It was very reckless. And I feel like Mr. Wade has shrugged it off. I had to hire a company to take down, because the fence, him taking the trees against the fence had also knocked down areas of the fence. I had to pay $1,500 for a company to come out. They removed no trees, but removed the fence and helped clean up the property because it was left a mess. On October 15th, I arrived to work to find my water line had been broken between the properties. Meanwhile, I have a salon and day spa. We need water. I called the county. They came, turned the water off. And Don came out, took pictures, and said the water line was broken because of equipment being used on the property to drill. They had been out there pounding the soil. He said that they were not supposed to be out there pending this violation, but they were continuing to do work. He said if I saw anyone out there to call the county. What started as me trying to be neighborly has really cost me and my business. I know that may be a civil or criminal case separate from this, but I think it's important that you are aware that the whole process is not about one tree being put down. The whole property was totaled, including my trees, and it was done in a very reckless manner. My concern moving forward, to wrap it up, and I asked of the county, I don't know the process, that surveys be required, that the property line be established, and that and somehow through the site plan process that those trees taken off my property are put back.
Thank you for your public comment. Is there anyone else who wanted to provide public comment? All right, we did start a little bit out of order, so I do want to kind of go through any exhibits you might have to offer, Mr. McGuire.
Yes, sir.
And please show them to learned opposing counsel if you would. So, sir, please let me know if you have any objection to them being exhibits in this hearing.
These were all photos that I had taken on these dates.
No objection.
Okay.
No objection.
Thank you, sir. All right, so we're talking about exhibits A and B? All right, let me just take a look at them. They'll be admitted without objection. I just want to have an understanding of the property that we're talking about. Yeah, these pictures are helpful, just so that I understand. That's that property is really threading the needle of development here. Okay, and let me just take a look at Exhibit B. Okay. Mr. Salmon, I always want to give, the respondent the opportunity to respond when there's been public comment like that, and it was pretty strong public comment, so what would you like, do you have anything that you do want to offer?
I have no knowledge of the dealings with the owner, so I'd prefer not to.
Yeah.
I'd prefer not to assert things on behalf of my client out of ignorance, but
I understand.
I will be informing my client of the situation and asking asking him to approach her.
Do you have any evidence that you would like to offer or any cross-examination of Mr. McGuire that you would like to make?
When I said that there was one specimen tree, I understand that's a tree of a certain size that, for which mitigation will be required. I do not contest that the other trees on the property were taken out.
Yeah, the issue, regardless of whether a tree is a specimen or not, is, the degree to which there's been a material change on the property for the purposes of this code section.
The other thing is, I would think that a fine of $5,000 would be sufficient to create deterrence.
And normally it would. I don't think I've ever been asked to issue a $15,000 fine. Maybe I have once. Yeah. Ms. Katu, did you have something you wanted to offer?
Yeah, just a couple things. First of all, the person saying they were the dermatologist had a pre-app in January of this year. We're told not to remove trees. They applied for the permit in August, denied, and they resubmitted on November 14th. So we do have a resubmittal in-house. I don't know if it's going to address it. It's a very, very tight site, and it's very hard to fit everything.
Yeah.
This is a very visible site on 44. So that is why I think part of the reason for the higher fine is it's getting a lot of attention.
I mean, it sounds as though, well, let me ask you, Ms. Katu and Mr. McGuire, have you had contact with Ms. Johnson in this case? Have you spoke with her, the person who came up and spoke? I don't know if she's the complainant or not.
Not until this morning.
Okay. I mean, have you had feedback, calls from the public or other people complaining about it?
I would have to ask. I'm not in the office during the day.
Yeah, sure.
Yeah. We actually have had contact with the neighbor. She's called our office.
That's
We
fine.
have to have calls as well. And we had to tell them there's an existing case.
That's what I'm curious
Yes.
about. Okay.
And for the record, Ms. Katu, can you explain what a pre-app is?
I'm sorry, yeah, pre-application meeting is a online meeting, a Teams meeting, and we meet with the potential applicants with all the reviewers to talk to what's required for a permit. So you need to turn in this plan, this plan, this plan, and that's when the idea of trees came up, and we told them they could not remove that.
Yes, I had a very difficult pre-app meeting in Charlotte County recently.
Ours
where
are
they,
not difficult.
They really laid down the law on me on something. But at any rate, my question is, does the county have an understanding of the timeline regarding when the clearing occurred?
The pre-app was January, the application was in August. Could you tell in the area when the?
The aerial I believe I had dated was from June 22nd of 25 that had full coverage. And then I was out there on September 8th.
My concern is that despite not having a permit and knowing that they didn't have a permit, they went out and cleared it, which, is an issue for deterrence as well as punishment. We don't factor retribution into these kinds of cases, but that's my concern. I'm looking at the exhibit just to see. How big is the property?
1.17 acres.
1.17 acres? Okay.
2.6, I'm sorry.
1.26?
Yes, sir.
Okay. Mr. Salmon, does that sound about right to you? Or do you know?
Sounds about right, but it's been a while since I looked at the
Mr. Salmon, I'll level with you. I mean, it's not going to be a $5,000 fine. It's not going to be a $15,000 fine, but because there are worse. There is still a worse case out there for this. That said, based on what I've heard, it sounds like a pretty bad case. So what I'm going to do is I am going to assess a fine of $12,000, and it's a one-time fine, but that's it. And of course, you can appeal my order by law if you want.
Thank you, Mr. Wall.
All right. Good luck.
Thank you.
Thank you.
I think that is the highest fine I've ever issued.
It is. The other one was 10,000.
Yeah.
Next case, Prater Corporation, case number 2025-1650. Code Officer Robert Denaro, page 26 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Good morning.
Raise your right hand.
Okay.
Yes, I do. State your name. Do what now?
State your name.
Oh, Thomas A. Reynolds, Patter Corporation.
Mr. Reynolds, are you an owner or an agent of Patter Corporation?
I am the president and CEO.
Okay, good morning.
Good morning, sir.
Mr. Denaro, did you put your name on the record?
I will now. Robert Denaro, Citrus County Code Compliance Officer.
Okay, good morning.
sir.
All right, now this is a contested case, correct?
Yes.
All right, then
yes.
please proceed.
Yes. The violation was fill on a vacant lot with no permit. As of this moment, Mr. Reynolds has his paid permit as of this morning. No?
He's applied for a permit? Yeah, that's okay. Take your time. Yeah, and I don't mind. I mean, let's
Okay,
find
sorry
out.
about that.
It's okay.
No.
It's okay.
Yeah.
In the meantime, while they check that,
Yes.
I am curious as to what the issue was, because that'll help me anyways.
The issue is
The fill.
Phil was brought into a
Okay.
vacant lot. So basically, that was basically it. I'd like to authenticate the following documents and request them be admitted into evidence.
No, no,
Photos-
no. Let's talk
Okay.
first about it. So
Okay.
ultimately, what would the county have been requesting, or what is it requesting?
The requested was one-time fine of $5,000 with administrative
Does
costs.
that change based on the fact that he has, if he has indeed successfully paid for and received a permit?
I would guess that it's up to you to what you were going
No,
to.
no, I'm just curious what
No.
you think.
We're just waiting for Ms. Kachuti to hear back, I believe. Can I see your exhibit real quick? I want to look at something.
Does my question make sense?
It does,
Okay.
but that's why I want to see his exhibits. Yes, this is a type of modification case where remediation wasn't a viable option, so it would cure the issue in this case.
So you wouldn't be seeking a fine if the permit has been pulled?
Correct.
Okay.
In this case.
No, that's fine. That's what I wanted to understand. So this is an important fact.
I don't know if you want to pass this to,
Well, actually, Mr. Nar,
Robert,
hold on to this. I haven't, Mr. Reynolds hasn't looked at that, but it's up to you guys.
JC, do you want to pass into a case that Joanna's not on?
Mr. Reynolds, here's what we're gonna do. We're gonna wait and check and make sure that the permit is all taken care of. In the meantime, if you don't mind taking a seat, we'll pull up another case.
Thank you.
Thank you.
Next case, Thomas Smell, case numbers 2025-1193, 2025-1194, and 2025-1227. Pages 32, 33, and 34 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth? So
Yes,
help
I
you
do.
God?
Yes,
Would
I
you
do.
Please state your name.
Thomas Smell.
Mr. Smale, have you ever been here at a hearing where you had fewer than 2 or 3 cases on an agenda?
Not,
You don't do it small.
At
I
the,
mean, you don't do it small. It's always got to be 1, 2, or 3 cases.
There've been a few of them down at the building department when they used to have the court there.
Yeah, right.
Yeah.
All right, well, all right, good morning.
Good morning.
Tell me about what's going on.
So this case was continued from last month.
Okay.
I need-
Which one? I mean,
All of them,
all
sir.
3?
Yes, sir.
And I did that by order?
Yes, sir.
Yes.
I did bring the exhibits that you admitted into evidence so that you could reference them if you need them. If you would like, I can start from the very beginning.
I remember the case, but I would like a summary.
Okay.
Yeah.
So it's a repeat junk case,
Yep.
which is 01193. The junk consists of car parts, appliances, scrap metal and wood, a lot of miscellaneous junk and debris. Inoperable, unlicensed vehicle, 01227. I did see that one of the vehicles I had previously noted as unlicensed appears to, it has a plate on it now, so I do think that there's at least one vehicle in the backyard that's unlicensed.
Let's start from first principles. Are all 3 repeat cases?
No, sir, just
Okay.
the junk case.
Just the junk case. So we'll treat that a little bit differently. And on case number 25-1194 regarding the fences, is that still in violation today?
Yes, sir.
Okay. And in case number 25-1227, is that still in violation today?
Yes, sir.
Okay. All right. So I would like to see the exhibits to the extent that they were admitted prior.
Yes, sir. So on the junk case, I have Exhibit A that you admitted last time. That's the findings of fact for the previous junk case. Exhibit B are my photos taken. And Exhibit C was the paperwork, the notice of violation, the notice of hearing, the general pre-hearing order, the posting affidavit. And then I'm adding Exhibit D, which is the letter from, or I think you actually, I'm sorry, I misspoke. You added Exhibit D last time, the letter from the attorney. And then I'm adding Exhibit F, which are photos taken on the 17th
All
of
right. I'd
November.
really like to see the exhibits.
I think you meant Exhibit E, not F. D-E.
Yes, I
Okay.
did.
Whatever was admitted. So, Mr. Smale, I'm just trying to make
Give it
sure
to
I'm
Mr.
on the
Smale.
same page so that we can talk about it.
Oh.
They're already admitted, right?
Some of them are.
Some of them, that's why I was trying to go over those.
Whatever has not been admitted, please show to Mr. Smale and see if he has any objection.
I know nothing about the pictures. I don't own the property. Mr. Nash does, right here. Back in 2000.
We'll get into that. So-
Yeah.
We'll get into
So
that.
I'm not on the property, so I wouldn't be able to
Ms.
tell.
Olson, I
pictures
just
of-
want you to show him the exhibits
Okay.
that are not admitted.
So this is the one that wasn't admitted. This wasn't admitted. Yeah, it's this one, sorry. These are all from Monday.
Monday?
Yes, sir.
So, Mr. Smale, FYI, these are in regards to what we call the junk case,
Right.
okay? So I want you to take a look at them and let me know if you have objection to them being evidence in this hearing.
I don't have no objection.
Okay.
I just don't.
And I understand you have a standing objection, about who the owner is and all that we'll get to that.
Yeah.
But I just want to take a look at these documents. Yeah. I want them all. Thank you.
Yes.
All.
Give him.
Thank you. All right, so all the exhibits that have been proposed by the county are now admitted into evidence. I am going to just briefly look again. Right. I always have to review the ownership situation. Okay, so I see that in the prior order. Now looking at the photos taken over a long period of time. All right, I've looked through A, B, and C. Okay, I'm now looking at the letter, which I had some concerns about, but I think we kind of got to the bottom of it. So let's see here. Our firm has agreed to represent Thomas Smale if a continuation is granted until January 2026. I didn't grant until January. The purpose of the length of the continuance is to file and remove the current tenants responsible for the code issues. First of all, are they representing you?
No, not now.
They're not representing you
No,
right now.
I can't
Okay.
afford it.
Okay, well, fair enough. Okay, so that's that. Let's see here.
But they did file the deed or transfer over.
Okay, we'll get into that. Mr. Smale, what is your understanding of the ownership of the property today?
Mr. and Mrs. Nash own the property.
Pursuant to an agreement for deed,
Yeah, back in 2017.
do you have a copy of it?
Yeah, I've got a copy of this, plus I've got a copy of the letter when they
Okay, well, please
Standing-
show it to the county, and I will,
And I got this from the county.
I'll take a look at it, but yeah. Give what you need to Miss Olson. Thank you. I don't know whether it'll be relevant or not, and we'll get into that, but I want
Right.
to see it.
Your Honor, if he wants to put those into evidence,
Yeah,
we
I
have,
just-
we have no
that's
legal
fine.
objection.
All right, got it.
I was notified that apparently the Nashes are here in
I
the
know.
courtroom.
Yep, they're here. All right, so let me just take a look. There's no objection to the contract for deed, which appears to be recorded. I'm just going to take a quick look at it. I'm curious to see what it says. May or may not be relevant. All right, I'll admit these as composite exhibit, I don't know what number we're on. F, all right. Well, I'm gonna go with F, and I'm gonna take a look in a little more detail at this letter.
On the other two cases, do you only have exhibits A and B?
No,
What number are you up to?
I have C's on the other ones.
Okay, Mr. Smale, what's your understanding of when the property was paid off?
We had a dispute on that.
Okay,
On the-
has it been paid off?
It's been paid off,
Okay, so it's undisputed that it's paid off.
right.
And have you ever executed a deed to the Nashes?
We tried to do one, but, in the county, but, it was turned down because there was supposed to be 2 witnesses.
Okay, I think I may have seen a copy of that. Have you tried to? I thought I saw
And
that, but
tell
okay.
you- Tell you the truth on everything, I got 3 kids. I got a 14-year-old, a 5-year-old, and a 4-year-old.
Okay,
Just turned that age, I'm taking care of them by myself.
right,
So for the last few years,
yeah,
I've been real busy.
I hear you.
And they haven't really bugged me about it, so.
So on this case, I mean, let me explain what county law says. I mean, the county may take a different position, who knows? But I think that the county has the ability to enforce these code sections against either the owners, the occupants, the people responsible. So you don't even necessarily need to be an owner to be responsible for it if you allow the junk to accumulate. Does that make sense? Okay.
Yes.
Okay. That's why I'm asking. I mean, what is your understanding of when ownership of the property transferred? When do you think it happened?
In 2017.
Okay. That's not true under the terms of the deed.
2021.
Okay.
Paid.
Now, my next question is, are you still in possession of the property?
No.
And when was the last time you were in possession of the property?
Me being on the
Yeah.
property?
Yep.
Since 2017.
Okay.
I met code enforcement on the property prior, because this has been going on for a little while.
Mhm.
And that-
Does the county have any evidence that Mr. Smale is responsible for any of the cases here today?
Well, I have met Mr. Smell out at the property before, and we have talked on the phone. He told me when I met him out at the property that it did not sell because the people buying the property never paid in full. So I was under, and that's what the PA reflected, that it was in his
Did
name.
you ever go to the property in person?
Yes, sir.
Did you
Yes.
ever see Mr. Smale at the property in person?
He met us there.
Okay. Did he ever tell you that he wasn't in possession of the property?
He said he did not reside there, that he rented it out or had tenants.
Okay. I mean, I'm a little confused about this. So what I'd like to do is ask if the county doesn't mind, I'd like to ask the Nashes if the Nashes are here to speak with them. Are you willing to speak? Yes, sir. I'll issue a subpoena if not, but, okay. Mr. Smale, could you move to the side? I'd like to hear from the Nashes. I need to resolve this issue before we proceed. Okay. Now, is it Mr. and Mrs. Nash?
Yes.
Can you please raise your right hand?
I do.
Have you heard anything that you disagree with so far today?
Yeah, quite a bit.
What?
Well, we didn't get ownership of the property until just here recently.
And when you say recently, what is your understanding of when you got
The
ownership?
day he filed for the quitclaim deed,
When was that?
28th of October.
So days ago?
Yes, sir.
Okay. And the notice of this hearing occurred before that?
Yes, sir.
Yes. Now, are you in possession of the property?
We are.
How long have you been in possession of the property?
Since 2015.
Or 2017? Or so before you even signed the agreement for deed, you've been in possession of the property?
My contract that you have a copy of
Yeah.
up there is 2015, correct?
You know, it says on here, let's look at it. I thought it said, it's dated October 23rd, 2017.
Oh, because there was.
But it
that
says this
supersedes,
contract
yeah.
supersedes the handwritten contract dated October 3rd, 2015.
Thank you.
Okay, so if you have been in possession of the property, then aren't you responsible for the cases that are in front of me?
Yeah, but we've never been properly written, told, or anything. We have to rely on secondhand information, which we've never had complete control of.
I mean,
To this day, we don't
Ms.
have-
Olson, have you ever had any contact with the Nashes?
Yes, sir. When I met with Mr. Smale out at the property, the Nashes were also there, sir.
Okay.
But she refused to talk to us.
So,
That's
Ms.
not true.
Olson, what is, I just want to know your understanding based on your personal knowledge.
Okay.
Do you have an understanding of who is in possession or controls the property?
So I didn't know that the property had been deeded over to the Nashes. My understanding was that Mr. Smell had it, just based on what he told me. I know that there was some sort of dispute with payment, but per what reflected on the property appraiser and
that.
what he said,
Yeah.
it was under
Yeah, I understand it
Mr.
hasn't
Smell.
changed on the property appraiser.
Now, I do know that the Nashes have been living there. On one of my inspections, I saw Mr. Nash walking his dog.
Okay.
And
Now,
Your Honor,
go
just
ahead.
for the record, Your Honor,
Yeah.
we would reflect that, I believe it's Exhibit D that Mr. Smale put in at the last hearing when he asked for the continuance.
Yeah.
He asserted ownership and that he was evicting
I
the
agree.
Nashes.
I agree. I mean, I understand that. So I'm trying to establish for the record a couple things. Now, Mr. and Mrs. Nash, have you received rents from the property in the past few years? Like, are you renting the property to anyone else?
No, sir.
Have you been paying over the past couple of years to Mr. Smale?
Nothing for the last couple of years.
Okay. Are you aware of the, let's see, are you aware of the representations made at the last hearing regarding ownership of the property? From
Meaning that Mr. Smale was the owner?
Well, here's a letter from Brianna Rosa. As the special master, well, actually, let me say, the purpose of the length of the continuance is to file and remove the current tenants responsible for the code issues. As the special master is aware, the filing and response time for the current occupant and subsequent removal puts the matter into January 2026. are you in the process of being removed? Are you a defendant to any case?
No,
All
sir.
right. Thank you for your time.
Okay, that's
Thank
it.
you. Mr. Smale, I'm just very confused by this because you, through your attorney, who represents you, said that, I'm going to read it to you again. The purpose of the length of the continuance is to file and remove the current tenants responsible. As the special master is aware, the filing and response time for the current occupant and subsequent removal puts the matter into January 2026. This is complete contradiction to some of the things that you've told me today.
Well, what it was is I tried to do an eviction before for renting, but couldn't do it because I was just a mortgage holder. And that's what he was going to do. The only way I knew to resolve the case is to do a eviction with the mortgage, whatever, how he was going to do it. And then we just came to determination of what money I thought they owed wasn't worth all that. It was probably in my best interest and their best interest just to go ahead and
Well, the problem
sign
is
it
you
back
now
on.
have these issues, and the question is who's going to be responsible. So there's been an attempt, I guess, to record the final transfer of the ownership conveniently before the hearing.
And it was successful. I was able to pull it up.
It's been recorded?
Yes, but
Okay.
it was since the last hearing and before this one.
All right. Here's the issue for me. I mean, I don't know who is primarily or secondarily responsible. I do find that the county lawfully has these cases. I don't find them illegal. I don't find there an issue as to who the respondent is. If the deed just got filed a few days ago, I don't see what basis I would have to kick these cases out. So I'm gonna at least go through them and we'll talk about them. So I wanna go easy to hard. And so here's what I'm gonna ask you, Ms. Olson. On the fence case, what's the issue with the fence and how long has it been like that?
It's been like that since before I received complaints. I've had complaints on that road before I've seen the fence. We're complaint-based, so. The issue with the fence is the front are porta potty sides. Like a porta potty was deconstructed and then used as a fence. I was able to gain access to the neighbor's property. He gave me permission, and in the back, there's more porta potties, and then there's also a tarp that's put up that looks like it's connected. There's another like mobile home in the back, and it looks like it's connected to the mobile home and something else.
So it's the material?
It's the material. And then when you're looking at the front of the property to the right, there's a gate, and it looks like that gate is made out of metal roofing, like not the corrugated, but the metal roofing material.
Okay. Now let's talk about the, so that's the fence case, the inoperable vehicle.
Yes, sir. So when I gained access to the neighbor's property, I could see that there was 2 trucks in the back that I believe to be inoperable. The silver Dodge I saw on Monday, and it is plated, so I'm going to assume that it's operable. Okay. When I was out there, I did not go onto the neighbor's property, so I did not see if the white truck was there. However, nothing has been provided to me to indicate that everything is registered and operable.
Okay. And do you know whose car that is, the inoperable vehicle?
Based on conversations with Mr. Smale and the Nashes, I believe it's the Nashes.
Okay. Now, let's talk about the final case, which is the quote-unquote junk case. What's going on there?
It's a lot of, Mr. Nash told me that he runs like he fixes appliances or engines, like business out of the home. And that's what's responsible for all the junk. So it's a lot of boat
Actually,
parts.
Ms. Olson, if you would.
Yes, sir.
I don't know if it's a radio, if it's a phone or whatever, but if someone could, okay, thank you. Sorry. That's okay, we'll survive. So can you please repeat that last sentence?
It's a lot of like boat parts, car parts, tools, a lot of miscellaneous stuff. I'm not mechanically inclined, so spare wood and metal. There's a porta potty in the backyard, glass,
Okay.
like windows.
Right. Who do you think should be held responsible, Mr. Smale or the Nashes, for the violations you just mentioned?
Your Honor, at this time, it would legally be Mr. Smale. At the time of the violation, he was the owner. He continued to be the owner. And under the code 16206, His responsibility was to notice them. They've been noticed here, and he had to notice our code compliance officer with a specific, in a specific format. He did none of that. We're basically being told today in court that now that it's been transferred, we should all just go away. So at this point, under the statute, we believe it's Mr. Smale.
I actually think you're correct, but that it's also incomplete, you know? So I believe you can hold the owner responsible. There's no doubt about that. I'm not questioning that. What I'm questioning is who is responsible, not just legally responsible. So it sounds like during the process of this ownership transfer, you know, the occupant, whether they're an owner or not, has done a lot of this. And so in the past, in some of these cases, what I have done is put a reduced fine in there if it's not the owner. But that would, it troubles me a little bit that, you know, the party that is not ultimately responsible but happens to be the owner today will not have a fine at all. That doesn't seem fair to me. So what I would like to do is talk to the Nashes again, Mr. Smale.
Yep.
If y'all would. I mean,
Yes, sir,
why
please.
should I hold Mr. Smale responsible for this?
Well, Your Honor, to be honest with you, first of all, the things that are in question is, first of all, the fence. The fence was approved back when Matthew Hampton was a code enforcer here. He was the one that allowed us to put it up and okay it. All we've done since then was to paint it. He wanted to know back then why we didn't go up an extra foot high. And I said, well, because I had these nice things I want. I don't know if, I haven't seen the pictures, so I don't know if you've got a picture of that or not.
It's not just the size, though, it's the materials. So you're just saying the fence shouldn't be a violation?
No, sir, because
Matt Hampton said so.
it's reclaimed plastic material that come off the side of porta pots, I have to agree. However, it's painted, it's very, very,
Well,
very good looking,
you've
I
answered
would
my
say.
question.
Okay.
I'll tell you that Mr. Hampton did not have the authority to approve it on behalf of the county. I mean, he was a code enforcement officer, unless
Right.
I'm mistaken. I mean, unless he had some authority I'm not aware of. Okay, so these fences, you know, if you read the code section, which is what I have to go by, you know, fences and, you know, they have all kinds of restrictions. They have size restrictions, they have material restrictions. You've heard testimony that there's a material issue.
Plastic and vinyl is what we've pulled up, and it shows plastic and vinyl is approved. Plastic, vinyl, wood, and I don't know what else.
It can be. I mean, but do you have to receive a permit?
No?
For a fence?
Yeah.
No, you don't need a permit.
So what's the issue with the material then? I heard it's made out of a porta potty. I mean,
It is made out of
but-
porta potty, which
but
porta potties are a different type of plastic. The code says PVC plastic, and porta potties, I actually had to look it up, and an AI helped me, sadly, are HDPE or polyurethane plastic, which are distinct from PVC plastic. They're apparently very different materials. I would think so. I would think looking, obviously, porta potties wasn't our intent. You're correct, Mr. Hampton has no ability to interpret the code that way.
Is the fence too high?
Is it too high, too?
Not the porta potty portion, but in the back, it's an unapproved material. The tarp is what I would call a fence, because it is blocking, and it's 20 feet high. So
It's actually over 10 foot high, to be honest with you. And all it is a temporary cover because we're spray painting motorcycle parts back there. We didn't want the overspray to get on our vehicles. And as far as the vehicles that you've mentioned, the first one has always, but both of them have always been licensed. I didn't keep tags on them. I've had tags stolen in the past. Okay, had she told me about this, I would have showed her the tag. They're both
We
licensed.
tried to show it to her, but she wouldn't talk to us
Like I
at
said,
that time.
we weren't the owner, and I understand her side of it, but here to explain it all, this is the facts. I mean, we've cleaned up everything. It's not that I work on stuff, what it was the stuff that she had seen was stuff from the hurricane. We collected, turned in as a medal, okay? Because that's what my son and I did. It's all gone, okay? I've cleaned up the place. It is true that I do have a license there on the property to work on boats and RVs.
But even with that, you know, you can't have a junk case. You
I
know,
don't.
These things,
I don't. It's all been cleaned up. That's what I'm saying.
as of when?
We worked hard. Well, since the
Is it
first
clean?
time,
I mean, has it been-
since the last time she was there, And we talked to Tommy, and he explained to us what was going on. I said, Tommy, don't worry, I'll take care of it.
Okay.
Okay? Since the last time she went to the backyard to my neighbors, that's all been cleaned up. There's a small portion to the right of the tarp there that belongs to my son-in-law. He was flooded out, and he's cleaning that up as we speak. So, like I said, I've done everything that the enforcement is asked from the information that I've received. Now, if there's something that I don't know about, I can't fix. So, like I said, we've done all we can do until we hear something different.
All right, thank you.
Yes, sir.
Mr. Smale, I do not think that you're primarily responsible for the violations, but I am very concerned. I do think you can be held liable, and I'm going to find you liable in part. But I'm very concerned by this letter that was sent on October 14th, because if all I have to go on is this letter and the prior representations that were made, I gotta tell you, I feel as if there's been deliberate misrepresentations made so that you could have time to file the deed and try to transfer responsibility to the Nashes. I don't think it's a coincidence that we get this letter on October 14th saying, oh, we need a continuance to January, and then suddenly this deed gets recorded 2 weeks later. Where there's smoke, there's usually fire, so why am I wrong?
I tried to, I'm sorry, this has been going on for a long time, and I wasn't allowed legally to go on the property to clean up anything because they still had the paper that, I was a mortgage holder. And the only way I was able to get it cleaned up or straightened out, I figured, was to evict them off the property. So that's the reason we did the letter, to try to get them evicted. I was going to go for that, but then we came up to a conclusion of an agreement on stuff. And I said, okay, I'll just finish signing it over because I can't afford to hire an attorney now, because it was going to cost a lot more than I figured it was. And the amount of money they owed me wasn't enough to kick them off the house. I was just trying to do something here. What was I supposed to do? I wasn't allowed to go in there to clean it up, and I was getting fined.
Okay. Is there anyone from the public who wants to be heard on this case? What's the county's recommendation?
For the repeat junk and debris violation, a fine of $250 a day from July 18th through November 18th, 2025, which is a total of 123 days, which equates to $30,750. Beginning today, November 19th, 2025, we request the fine to increase to $300 per day and continue to accrue until the violation is fully abated. For the unlicensed inoperable vehicles and the fence violation, a fine of $100 per day beginning on the date you deem to be sufficient for abatement. We also ask for the special master to impose administrative costs associated with each case.
Okay. Mr. Smale, in all three cases, I'm going to find you liable as an owner. However, on the junk case, I will find that because it is a repeat violation, that from the date range provided by Ms. Olson, there will be a $20 a day fine, and from today's date going forward, a $10 a day fine. On the inoperable vehicle case, I will grant you 15 days to bring it into compliance and assess a $10 fine to the extent that it's not brought into compliance.
And it's $10 a day?
Yep. And on the fence case, same thing, 15 days, $10 a day to the extent it's not brought into compliance. This is due to the fact that you are an owner under Citrus County law. You can be held responsible. Additionally, I really think that there was some misleading of the court. Now, I do think the Nashes are primarily responsible, and if cases are brought against the Nashes, if these are not brought into compliance as ordered, the fines will be much higher. Thank you.
Thank you, sir.
For the record, what is Exhibit F in the repeat case, the two letters that Mr. Nash put in, are those also going to be Exhibit Ds in the other two cases?
If you wish, yeah.
Just for consistency's
Yeah,
sake.
I like that. Thank you.
Can I ask you a question? how am I supposed to enforce?
You may have to consult your lawyer on that. Thank you.
Okay.
Next case, Prater Corporation, case number 2025-1650. Code Officer Robert DeNaro, expert on the case, Joanna Katu, page 26 of your agenda.
And Your Honor, I am never more happy to be wrong in this case. He actually did get the permit this morning, so there is no violation at this time.
Okay, does the
county
county want to
dismisses the
dismiss the
case.
case? All right,
Yes.
thank you. I don't think you were wrong, you just didn't know the current
Not this
situation.
morning, who knew?
Okay,
But
all right.
awesome.
Sorry for the confusion.
No, that's okay, great. Mr. Reynolds, you're free to go.
Next two cases, Jerome W. Casper, case number 2025-1598 and 2025-1610. Code Officer Cody McGuire,
Actually, you're always free to go, everyone is free to go. I have no authority, but anyways,
pages 17 and 18 of your agenda.
thank you.
Are you able to stand? You able to stand?
Yeah.
Yeah.
Good morning, sir.
Good morning, sir.
Oh. Yes, I do.
Okay.
Thank you.
Your name, please?
Thank you.
Your name?
Jerome Casper with a K, Casper.
All right, so for the record,
Thank you, sir.
your name is, you are Jerome Casper, sir, correct?
Yes,
All
yes,
right,
sir.
thank you. Mr. McGuire?
Cody McGuire, this is case number 2025-01598, and then also 2025-01610. One is accumulation of junk and debris, and the other one is unlicensed inoperable vehicles. In a summary, the property is 11655 North Pan Am Terrace in Ellen, Florida. It's 1 acre and it's zone CLR. He's just got a few unlicensed vehicles and some junk through the property.
Okay.
Yes.
Do you have any photos or exhibits?
Yes, sir.
Mr. Casper, can you let me know if you have any objection to
Yeah, that
these?
one, the wind damage, yes. Yeah, I have a metal shed.
Hold on, Mr. McGuire.
The lumber.
Mr. Casper?
Oh, I'm sorry, sir.
What I'd like to ask you to do is look through these documents and let me know if you have any objection to them being evidence.
Well, the reason here is because I am confused about the violations. One basically about the automobiles,
Correct.
they're antiques,
Right.
which I'd like to find out. And then the debris, what debris is he talking about,
All right.
and how do I correct it?
Well, let me ask you this
Yes,
then
sir.
first. We'll get into that. I want you to look at these documents and let me know if you have any objection to them being evidence. Okay?
Do you
Thank
think these
you.
are fake in any kind of way?
This is objectionable?
What's that?
That's,
Well, he's gonna go over them.
oh, yes. That's a carport. That is my trailer in the front yard, 8-footer.
Right.
They're hauling my junk. Yeah, that's been cleaned up a little bit. Yeah, that's the back end of the backyard, and that's my lumber that I'm gonna use for work.
It's just other angles of it.
Yeah, my main problem is I'm handicapped, and I had a helper, but he quit, because he,
That's what you have right there.
yeah, I got all that, I
Okay.
understand all that.
And
And
then
that's my 55 Oldsmobile.
Yep.
And the boat, the boat, I took the boat, moved it, and took it to a dealer and had it looked at. And that's my that's a recent too. Yeah, that's my 1980 Triumph. It has a bad starter. I didn't buy it yet till I got done with court.
And then
I
that's
got
all
no
metal.
objection to those pictures.
There we go. Thank you.
Whatever he's got is true.
They're not fraudulent. They're not created by an alien,
Yes, sir.
unless you are one.
Well,
Okay.
sir,
You're from Earth.
Even if he was, it's okay,
I'm,
you took the
Okay,
pictures.
okay.
I'm
Yeah.
gonna be going on 79 years old, and I never had a complaint in my life. But
Well, that makes
I'm
one
here
of
to
us.
correct the problem as needed. I just confused, and one of my confusion, if we wouldn't mind, is talk about my antique automobiles, and they're not junks. Trust me. There are 4 of them involved. When I moved from Missouri, which I'm still not finished moving, well, I sold the house finally, and I have a trailer full of stuff. I'm handicapped permanently for life. I have a court order brought with me saying that I'm handicapped for life. So I have to hire people to help me. I hired a guy, but he quit a month ago because he had that virus, the virus. And so I'm looking for someone, and I could afford someone. I pay minimum wage, $14 Florida wage, and I work 3 days a week with my helper. But I'm looking for someone because of my handicap. The problems with the vehicle. In my backyard, I have a 1950 Lincoln.
Yeah, it's beautiful.
Mustang engine, auto trans, new drive shaft, new rear end, 4 wheels, disc brakes, new exhaust.
I get it. It looks good.
Yeah, the only thing and beautiful interior, gorgeous interior, and all new dash gauges. The only problem is I'm trying to get at the windshield wiper motor stop working.
That is not the only problem. Let me explain to you what the other problem is.
Yeah.
The county believes that it is either inoperable or it doesn't have the proper registration or otherwise. So let's ask Mr. McGuire, because it's his case.
Yeah.
Mr. McGuire, what is the problem with that beautiful old antique car?
Thank you.
Unfortunately, it just doesn't have a tag displayed on it.
Did you hear that?
The reason why I haven't licensed it, because my 50 Lincoln, my 55 Oldsmobile, which is also a rust-free, gorgeous car, I didn't buy plates because I'm selling them.
Okay.
I'm going to sell them.
So, Mr. Casper,
So I don't know what to
here
do.
you have the problem. The problem is the county thinks you're in violation of the law. You agree that you're in violation of the law, but you
Yeah.
have a reason. You say it's okay.
Yeah,
so
they
we'll
got
get to that.
plates.
We'll get to that. Now, the other case is the quote-unquote junk case.
Yes.
All right. Now, I've looked at the photos.
Yes.
I think there's junk there. Do you disagree?
Well, yes.
Okay.
The wood is there in the photo because I'm going to use it to build things with, and I stacked it up against the building. If I have to lay it on the ground, tell me what I got to do with my wood.
Mr. McGuire, what is the junk in this case?
It would be like the discarded automotive parts. I believe there's some appliances. Looks like some
Yes.
piping.
Mr. Casper, I'm looking at page 5 of Exhibit A. I'm going to show it. I don't know
Yes,
if you can see
that
it.
is a
but I'll tell you
four-wheel
something.
dolly for hauling my cars
It's
around.
not just the dolly. It's
Yeah, it's a dolly. And the
no, there's
reason
more
I
than
have
the
it was
dolly.
to haul my
There's
cars.
this. There's all kinds of disconnected trailer parts.
I could clean
Sir,
all that up.
let me. Yes,
Yes,
you
sir.
can, and then that's what we'll get
And
to.
I will.
Even the stuff on the trailer. I mean, you're not allowed to just have that in the open. It's got to be in an enclosed space. So the question here is,
Yes, sir.
how much time do you need to solve both of those problems?
Well, I need a helper,
Yeah.
and that's my problem in the last 30 days. But I could start doing things on my own. The only thing I do have a question in is the automobiles. Do I have to buy plates if I'm going to sell them? And I'm going to sell them.
Mr. McGuire, when did you start this case?
I started this on September 8th of 25,
When did you first have contact with the owner?
this morning.
Okay. So, Mr. Casper,
Yes.
I hear what you're saying, so I'm going to give you a time to comply. Okay?
Yes,
I
sir.
don't know all the steps you have to do. That's not my job. My
Yes, sir.
job's actually really easy.
I understand.
I go, I mean, AI could replace me like that. I think it's harder to replace, you guys than me. Mr. McGuire, what's the county's recommendation on these cases?
$100 per day per violation.
Okay. So, Mr. Casper, on the vehicle case,
Yes, sir.
normally I give a couple weeks. In this case, I'll give you a month. I will give you a month, okay? 30 days to get the car licensed, properly tagged, or get it off the property, which means sold, okay? 30 days. Now, that looks beautiful.
Yes.
I mean, all right. I think someone will take it. On the junk case,
Yes, sir.
I am going to give you 45 days to bring
Yes,
the
sir.
property into compliance. That's a month and a half to find someone, maybe one of Mr. Smale's kids, because maybe they'll help, to bring the property in compliance. And if either of these cases is not brought into compliance as ordered, it will be $100 a day. So please get moving.
Now, when I finish these items, do I contact
Yes,
him?
yes.
Do I have your number?
I'll get yours.
Thank you
Now,
very
is there
much.
anyone from the public who wants to
Also,
be
as
heard?
far- yeah.
Is there anyone from the public who wants to be heard on this case before we let Mr. Casper go about his way?
Yes, and
No.
as far as the junk, I'm building a pile. I'm gonna get my 8-foot trailer. I have a gantry out in the backyard. I'm gonna load it up and get rid of it.
I've been
I'm
told,
just gathering
unfortunately,
it together.
unfortunately, I've been told that you can't just blow it up, which is
Yeah,
something
I
I've
know, I know.
recommended in the past, but good luck.
I'm guilty.
All right.
And I'll correct it.
Well,
I just wanted it understood.
there's a first time for everything. Thank you, Mr. Casper, and
Yes,
good luck.
sir.
Thank you.
Next case,
Oh, yeah.
Benjamin and Leanna Hammersley, case number 2025-1541, Code Officer Alan Jonason, page 14 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Thank you. Leanna Hammersley.
Ben Hammersley.
Welcome, the Hammersleys. Now, Mr. Charlton, I do want to just ask you a question. Do we have someone with a child here? Do we want to take that case next after this? Okay, thank you. All right, Mr. Johnson.
Good morning. Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-01541, Citrus County Land Development Code Section 4002, site development without a development order or permit. Address of the violation is 2629 North Perfect Point, Hernando, Florida. Property owners are Hammersley Benjamin and Hammersley Leanna. This property is approximately 0.83 acres and is zoned CLMH and was purchased on 4 July 2025. I have good service via signed certified mail receipt and posting at the LeCanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 4 September 2025, and an aerial photo from the property appraiser's website dated 23 June 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the certified return mail receipt, and a copy of the pre-hearing order.
Before you show the documents, is it Mr. and Mrs.? Or
Yes.
you, okay. Are y'all contesting whether a violation has occurred?
I don't think we're really contesting it. I mean, we know we're guilty, but we're making corrective steps. You know, it was pure ignorance, not to be unlawful.
It's not the first time that a case like this, actually, you probably sat here for a couple. Mr. Johnson, have you had contact with the owners prior to
I have
today?
not.
Okay. All right, then what I'd like to ask you to do is to look at the photos and just let me know if you.
I'm sorry, I have had.
So we
spoke-
did do an open records request, so I already seen everything via email. So
Well, I don't know if you know necessarily what they want to introduce and have me see, so I need for the record so that you can't, you don't say later, oh, they didn't show me this or it didn't appear. I go by the book, unfortunately. So, yeah, if you would show them. Does it all look like your property?
Yes.
Okay, okay.
Definitely is.
All right. Did y'all actually buy the property on Independence Day, like July 4th?
So that was not our plan, but the property had been sitting on the market for months and months. Oh my God, we finally found something. We've been looking for over a year.
Yeah.
And the night before we were to seal our deal, someone came in and outbid us. So we had to sweeten the pot and do whatever we could to try and get it.
Time was of the essence. It looks like great property.
It's beautiful. It's our forever ending spot.
Perfect point.
It's perfect.
Oh, is that, yeah, perfect.
Yes.
Perfect point. All right, so we've heard that there's not a lot of argument here, but there may be based on what the county's wanting. So what does the county want here?
One-time fine of $5,000.
Okay. Would you all like to tell me a little background of what happened on the property and why we're here?
So we purchased it.
Yep.
We spent a lot of time at the lake. So like I said, it was pure ignorance. We wanted to take our family there. We spend every weekend on the lake. We're airboaters. It was heavily wooded. We thought we could clean it up, make it more eye appealing. Like I said, we're going for a single family residence there. We already submitted our permit application on October 27th. The letter said that corrective action should have been taken on October 4th, I believe, but we didn't even receive the certified letter until October 16th. So we have been under the gun trying to do everything we can in our power. Every day I'm on the phone
trying to move forward the next step. We have an engineer, we have our plans. Like I said, we have a permit number, we paid our deposit already for our building.
The problem on these types of cases is that essentially when someone clears it, the county takes the position that it's irreparable. Now, of course, you could put trees in, you could re-put it back, but you're not going to because you're going to build anyways. So the point of these cases is to deter people from taking that step ahead. So, I mean, I'm going to have to find some kind of a violation here. Now, is there anyone from the public who wants to be heard on this case? All right, so normally what I do, if I am convinced by the owners, and I am, that it was a genuine mistake, I'll assess a one-time fine of $2,500. I cut the county request in half, and you go on your way.
I just have one question. Can we pay that here today? Because they're
I
holding the
don't-
permit up till we need to clear the case.
Well,
It's not?
okay, I'll issue the order. The county's great at getting my orders out, so if there's any delay, it'll be on me, but I'll work as hard as I can.
All right, thank you. Appreciate it.
Good luck.
Thank you.
Good luck to you.
Thank you.
Next case, Kevin McDonough and Cassandra Marcus, case number 2025-1570. Code Officer Cody McGuire, page 21 of your agenda.
Good morning. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
If you'll state your name, please.
Cassandra Marcus.
Okay, good morning.
Hi.
All right.
Cody McGuire, case number 2025-01570, accumulation of junk and debris. The address is 5149 West Amon Street. In Denellen, Florida, it's 5.35 acres and it's zoned TCU. The property owner is Kevin McDonough and Cassandra Marcus. And I have good service posting the property. This is just a junk case, sir. There was discarded construction materials, automotive parts, concrete, stuff like that.
Ms. Marcus, are you contesting whether or not there's a violation on the property? It's fine if you are, just.
For me, I didn't do the violation.
Okay.
I have evidence,
Are
which
you,
I will submit.
well, let me ask you this. Are you an owner of the property?
I am an owner, but I was not aware of a lot of the stuff that Kevin was doing. And then I did go and take pictures when he was moving the Connex from his last time when we were in here, which I have this one from back in February while I was in the hospital with my child. So I went ahead and took pictures before he made this.
I'll take judicial notice that you have a child.
No, like my infant was in the hospital for so many months the first time around when Kevin got us into trouble.
Okay.
So then I came here and made my statement. We
Well,
got 90 days.
The issue, though, is that as an owner, you've sat here for some of these other hearings.
Yeah.
I know, if I find that the property's in violation, it's gonna go against all the owners.
Yeah, I have a lawyer because Kevin filed a civil lawsuit actually right here in Citrus County pertaining to this property.
Really?
So what he did is he decided to go ahead and make a huge mess on these dates and then get arrested 2 days prior. So I would be liable for the situation. So I went ahead and hired a lawyer, since he hired a lawyer too as well. But I also have a witness statement and pictures that I would like to go ahead and hand over. That
And
you
we'll get
guys can
into it.
keep.
I just wanted to know if you were contesting, I guess. So go ahead, Mr. McGuire.
Okay.
We'll get to your evidence, yeah.
Good service via posting the notice of hearing on the property in the Canto Government Building. I'd like to authenticate the following documents and request that be admitted into evidence. Is going to be Exhibit A, photos taken during initial inspection on September 5th, 25. Corrective action inspection on September 24th, 25, and photos of my final inspection on November 17th of 25. And then Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, a photo of the property posted, and a posting affidavit.
All right, Ms. Marcus, can you take a look at these documents and let me know if you have any objection to them being evidence?
It's all Kevin's stuff, yeah. It's all him putting his stuff from his company. Yep, that's all Kevin's stuff, yeah. Which I have that right here.
Yeah, those depict the same thing.
Oh, no, the pictures I got are a little different.
Oh, you leave with the Connex.
Yeah, from when he moved it and made more debris. See, all that stuff, that's why this was all filed. That's why I hired a lawyer, because I want him.
I just need to know if there's objections to the
No,
documents
there's no
being evidence.
objections. That's all from Kevin
All right, then let's
McDonough's
introduce
company.
them and I'll take a look.
Okay.
All right.
do
So
you
without
wanna look at
objection, what's been proposed as Exhibits A and B are evidence. I am looking through it. This is just a,
I didn't know how to do it, so on each page here, I did.
is that your
Yeah,
evidence,
there's
Ms.
nothing
Marcus?
back. Yeah, I was gonna have him look at it.
All right, well, if you don't mind, let's hold off on for a second. So I'm looking through the photos of Exhibit A. I see different kinds of violations. Not just one type, but 2 or 3. So on the scale, it's not a 1 or a 2. I don't know if the scale will be recognized on appeal, but let's see. Okay, I think I have an understanding of what's going on, at least from these photos. And
You'll see.
first, I'll let Mr. McGuire complete his presentation. Go ahead.
Okay. All right, so on September 5th of 25, I conducted initial inspection and observed that property to be in violation of all those items that we had mentioned before. I have talked to Ms. Cassandra a few times on the phone throughout the process, and basically the property still remains in violation.
Okay. Do people reside on the property? Is it vacant?
So I have the permit. There's an issued permit, but the home was never installed.
Okay, and it hasn't expired? The permit hasn't expired?
Expires this week.
Really? Okay.
Yeah,
Okay.
I'll get down to that with you.
All right, so Ms. Marcus, I would like to hear, based on the photos and the testimony, I'm going to find that there's a violation. So I want to know what you have to say about that.
Okay, so I went ahead and handed over to Cody all of the stuff that I gathered up to show, along with a witness statement. He was gonna be here today, but he had a dentist appointment, which is my neighbor. So Kevin McDonough owns a tree company, and he's also a hoarder. He's never owned anything before in his life until we purchased this property. And him owning a tree company, he gets all this stuff and he brings it. So me being a stay-at-home mom, I also had a newborn baby, then he got sick, so I was gone for a long time. Kevin made this property a huge mess. I literally bought a home to put on the place. And then right as the week the home was supposed to be getting out there, Kevin decided to make a bigger mess of the property. And then next thing you know, we just pulled out, broke up. And now, like I said, lawyers are involved. And I'm trying to make sure that my lawyer goes after him for this, because this is all Kevin McDonough, owner of True Tree Service. And that witness statement too will also let you know, because he has trucks coming in and out left and right, just dumping stuff. And when I mean dump, like he will dump debris down to rocks, concrete blocks, to our windows that we didn't even need windows for.
What is the nature of the lawsuit between you two? Is it like for partition?
So he
or?
filed, basically he forged my name on a document. So that's why I hired my lawyer. And he also filed other civil lawsuits out of Marion County, which I'm dealing with, which at the end of the day, he's just being vindictive right now because of where he's incarcerated at, which him getting in all of these criminal activities is why he's incarcerated. But no, my lawyer is going to handle that, but I would let her know, and I sent her the information regarding this hearing, and that it was in code compliance, and I told her that would go, let her know what the outcome was, and then she would deal with it. She would go on after I relay her all the info, basically, and then go from there.
What is the county's position on the proffered documents?
But if I can get
I'm sorry, Ms. Marcus. Okay. They want to, go ahead.
I took those photographs right there. Yeah, so I actually had the photos, and I have them locked in my Google Photos on my phone.
Okay.
So what I did is I just basically, so you guys could have the dates on them, is I just took some more screenshots of them, and then took them over to the notary place, and they printed them out for me yesterday.
And the handwriting on all of the documents?
I just did that while I was back there, just to make little notes. I wasn't quite sure how to do it.
Your Honor, I'm not sure how much it goes to relevance, but we have no objection on the authenticity.
I think they're relevant, but I think they're relevant for the county's case. I mean, it goes to show that there is a violation on the property.
Yeah, it's all totally up to all Kevin McDonough. We're tenants in common, 50-50 on that. So I'm just trying to, I had no part of it, literally no part. Like, that's all him. And then next thing you know, 2 days later, he gets arrested, and then he gets out and got arrested 2 more times, and now he's stuck in there until he gets sentenced to prison, because he knows at the end of the day, he's gonna leave me to deal with this mess when he knows I can't even work because my infant's disabled. And I'm trying to get disability on him, so he can't even go into daycare. So he did that to me on purpose. So that's why I'm gonna have my lawyer deal with that situation.
I'm gonna admit the documents that you proposed, and I will make that a composite.
It's True Tree Service, he's the owner of it.
Actually, you already have them labeled, so you have,
I tried, I was doing it back there.
that's
It was kinda
interesting,
hard
okay.
To do with the baby.
So you have a proposed, your own A, B, C.
I tried.
All right, then I'll just introduce them as
And there's a-
respondents' exhibits as labeled, and I'll make the letter exhibit
That's
G.
a witness, yeah, the letter is a witness statement.
Okay. But you realize, I mean, this doesn't say that there's not a violation, it
Yeah,
just
I
says.
know
Yeah,
there's
yeah,
a violation.
Okay.
It's all
Okay.
Kevin McDonough with True Tree Service, and he needs to be held liable, and that's what I'm gonna make my lawyer do.
You do need to consult a lawyer about
Yeah,
this,
I
for sure.
have one. No, I
Okay.
do have one.
Mr. McGuire, well, actually, is there anyone from the public who wants to be heard on this case? I don't see anyone. Mr. McGuire, what's the county's recommendation?
$100 per day or an administrative cost.
Okay, I'm gonna grant 30 days to abate the violation. If it's not brought into compliance in 30 days, there will be a $100 a day fine. But look, it's gonna be on everyone's name unless you can legally get that changed.
Yeah, I know. So we have a hearing set for one on January 6th.
Mm-hmm.
So for the property matter, I don't know how long that's gonna take, even though like my lawyer's already put down that she's representing me in both cases.
Who's your lawyer?
Karen, Karen is, can't
Leandro?
pronounce last name. She's out of Spring Hill.
Yeah, okay. Well, look, I just think
That's
your
their law. That's what
lawyer
it
needs
is.
to be fully advised on this, but that's the order that we'll issue.
Yeah, I was gonna say, can you give me 60 days? Because I'm trying to get the funds actually for her to go through with the other one too.
Why would you need 60 as opposed to 30?
Because I have to give my lawyer extra money, and my money's in an account, CD account, because it was for my house.
Well, but I mean,
So, if
we're
I-
just talking about cleaning up the property, so.
Yeah, I gotta.
Is it your intention to clean up the property?
My intention is to somehow force True Tree Service to do it, but I gotta get the funds up, which I had the funds, it's in my
What
bank account.
service? The what service?
True Tree Service,
True Tree Service.
yes,
To clean up.
LLC. Yes.
Okay, well, it doesn't sound like more time's gonna help with that. I mean, nothing in these cases gets resolved in 30 or 60 days, to be candid with you. So I'm gonna treat you the same way I treat the others,
Yeah.
and you got 30 days, okay?
Okay, so 30 days, and then after 30 days, then.
A
the
fine starts on the
Okay.
property and your
So-
names.
Is there a way that I could get paperwork for today, and then I can show it to my lawyer?
No, but I will issue an order as soon as possible.
So does that come through the mail? Because people are going by the property and stealing mail.
It'll come,
And also too, like, the thing that was posted, I've been trying to call you, by the way.
ma'am,
Yeah,
we'll
well,
make sure an order gets to you. I mean, follow up. If you haven't gotten an order in a week, follow up with Mr. McGuire.
Yeah, because down to where I had to call JC about it, the one that was posted at my gate,
Mm-hmm.
like, I've been going out there like every couple days now, because I've noticed stuff has been getting stolen. And I went out there 3 nights in a row, I didn't see no thing on the ground. I saw a thing from the sheriff's department, and then the next day I go out there that evening, and I find the note for the court hearing. And I called, and they said it was put out there since the 5th. And then I'm like, I'm just now getting it, and I've been going out there, so people are taking things from the property.
Thank you, ma'am. All right, next,
So if I can
next
give you
hearing.
an address to send stuff.
Next case, Maribel Rosa and Jesus Sepulveda, case number 2025-1522. Code Officer Erica Olson, page 31 of your agenda. Expert on the case, Land Development Director Joanna Katu.
I do.
I'm Maribel Rosa.
My name's Jesus Sepulveda.
Good morning, ma'am and sir.
Good morning.
Please proceed.
Erica Olson, Citrus County Code Compliance. Case number CE 2025011522, a violation of Citrus County Land Development Code 4100, site improvement plan. It's just a lot of fill dirt was brought in without a permit.
Okay, so that's the gist of it. And so that's when I normally turn to you and say, you know, are you contesting whether that happened or not? Are you
Yeah.
contesting?
Well, not that it did
Happened.
happen.
Yeah.
Yeah. It's
And
just
are you
contesting.
contesting whether that's a violation of the code? Okay, please proceed.
Yes, sir. The address is 1600 West Noble Street, Lecanto, Florida. It's approximately 4.54 acres and zoned RURMH. The property owners, Maribel Rosa and Jesus Supalavita. I have good service via signed certified mail return receipt, posted at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on the 2nd of September, 2025, my corrective action inspection on the 18th of September, and my final inspection on the 17th of November. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified, mail return receipt. And a copy of the general pre-hearing order.
Okay. Ma'am and sir, could you take a look at these documents and just let me know if you have any objection to them being evidence?
Yeah, that's my dirt.
That's mine. I'll look at these two.
What is this?
This is the notice of violation that was sent. This is the notice of hearing that was sent. In the notice of hearing, you also get your general pre-hearing order, which is the next 3 pages. And then the last page is just,
This is stuff that was sent in the mail?
yes, sir.
Okay. Yeah.
You good?
Yeah, I acknowledge
Okay.
it.
All right, I haven't heard any objection. We'll admit them as exhibits A and B. Just so I know, is there anyone from the public to be heard on this case? I don't see anyone. All right, so let me just take a look at this and so I can see what's going on. It's also a very nice property. Let's see. Although there's no nice or beautiful property exemption in the code, but.
If there were.
Yeah, exactly. All right, please proceed.
Yes, sir. On September 2nd, 2025, I conducted my initial inspection and observed large piles of dirt on the property. Upon returning to the office, I conducted research and confirmed that no permits had been issued and a notice of violation was issued on the 9th of September. A corrective action inspection was conducted on the 18th of September, during which I confirmed that the fill dirt remained on the property and a notice of hearing was subsequently issued. On November 17th, I conducted my final inspection and found that although the dirt had been spread out, it did remain present on the property. After returning to the office, I verified again that no permits had been issued or applied for.
Have you had any contact with the property owners?
I've had contact, I believe, with the other Jesus. Is that your dad?
Yeah.
I've had contact with Jesus Bolavita Sr., your husband.
Is he
And
okay, so who are the owners of the property?
I'm Maribel, I'm the owner, my husband, Jesus Sepulveda.
Gotcha.
Yeah.
And, all right, so how did the contact go?
it was fine. He said that he would, he wanted to comply and he was gonna try his best. I guess he was trying to get a permit or something, so I told him that he needed to talk to Building and Land.
Okay, so what it says in the notice of violation is, a site improvement plan shall be required for any development proposed on improved land. The following corrective action must be taken by September 16th, 2025. Obtain a site improvement plan.
Yes, sir.
Has a site improvement plan been issued?
No, sir.
If one had been issued, would this case have gone away?
Yes, sir.
Okay, so you wouldn't have requested anything, like a one-time fine or anything, if a site improvement plan had been issued?
No, it would have abated it per the notice of violation that was sent out.
That's interesting. Is there anything else you want to tell me?
No, sir.
All right, what would you guys like to talk about?
Well, I have some papers if I could.
Whatever you think is relevant. I mean, I want to hear what's.
Can we clarify that he's technically a member of the public and not the owner?
Well, you want to switch places, I can switch
I'm not
places.
No,
Asking
no,
for the
no,
record.
Yeah, for the record, I think
I'm
it's,
just representing my parents.
yeah, it's okay. I mean, but I think the county's point is we want to make clear for the record who the owners are, who's not an owner. And so, Mr. Sepulveda, I think what she's saying is you're not, in fact, one of the owners of the property, correct? Okay, that's established for the record. Now, could you please get those documents to Ms. Olson, and I will hear from the county as to whether or not they have a legal position on this. But I do want to hear y'all's side, I mean, independent of the documents.
I have a written statement.
Yeah, I mean, whatever, now would be the time to send it to
Right
them
now?
and
Oh,
let them know.
do I
Oh,
just-
you want to read that?
Yeah.
Yeah, that's fine, that's fine.
Okay. It- I'm gonna object to two of them because I just honestly don't know what they are. I can't tell from reading them if they're statements from the owner. So for relevance legally, and then the other one looks like a certification for aquaculture. I would also object to that for relevance.
All right, then let's hold off on introducing them necessarily until so what they're saying is they need to understand why these documents are relevant first.
Yes,
And could you give the documents back to the respondents? So let's go through this slowly. First, I want you to present whatever you want to tell me first, and then we'll get into your documents. So then, because that will make your documents make sense.
Okay.
Yeah.
Good morning, my name is Jesus. I'm speaking on behalf of my parents and about the property in question. I hold a valid aquaculture certificate from the Florida Department of Agriculture and Consumer Services under Florida Statute 597.004. Certified aquaculture is classified as agriculture. Florida's Right to Farm Act, Statute 823.14, prohibits local governments from restricting bona fide agricultural operations. I am simply exercising my right to conduct aquaculture on my property. I provided my certificate and a copy of the relevant statutes. Based on state law, this activity is exempt from county ordinances, and I respectfully request that this case be dismissed.
Okay. And so I assume that will help the county understand why the certificate is relevant. I'll admit that as evidence. And then what is the other document you sought to introduce?
It was just, this is the response for the mail that I got my parents got in the mail. It was just addressing the situation.
Okay, so it's
basically my
your
statement.
position.
Yeah,
It's like
my
your
position.
And you intend to rely on what's written on that document? It's like a brief to me to help me
I
understand.
believe so, yeah.
Okay.
This is just mostly was for you, just to show you like the relevant statutes.
I want that.
And-
So, I mean, if you would show it to the county, I mean.
And then this one here is just the actual copy. I think I have the actual certificate as well, if that's relevant to.
I don't need the original. I mean, if you have a copy,
It's a
I don't want to
copy.
take your original. I mean, I'll tell you as a matter of, I'll wait till the county's done. Okay. So I am looking at a document that I guess appears to purportedly authored by Jesus Sepulveda, address 1660 West Noble Street, has a phone number and an email address. Okay. I don't want to necessarily read them on the record. So let me read this. Let me take a moment to read it. Okay. I'm going to admit it as evidence. We'll talk about it, that letter. And then there's a statement of agricultural exemption, aquaculture. Okay, I see that. I'm just going to read it in a little more detail. All right, and I'm now looking at a copy of the aquaculture certificate of registration. Let's see. Mr. Sepulveda, when did you receive this certificate?
It renews every year. You have to pay a $100 fee, and we've done it twice, so it's been 2 years since we've.
So like 2024, June of 2024-ish? Because it says it expires June 30th, 2026.
26, so we renewed it this year.
Right. Okay. I'm going to admit it all. I'm going to have the, let's have the certificate be exhibit. Let's see, you gave me A and B.
Yes, sir.
So let's have that be C. Will be a statement of agricultural exemption, aquaculture, which I think is, you know, kind of a respondent brief. That'll be exhibit D. The untitled document, but, you know, I guess was received by Citrus County Utilities on September 8th, 2025. In regards to a different case number, will be exhibit.
I got those case numbers mixed up.
No, that's okay. I'm not finding that that's important, but I'm going to ask the county, was there another case that you had on this property?
Not on,
Okay.
not for code.
Okay. I assume that it seems to be related to the quote-unquote unpermitted construction of a metal garage and carport. Are you aware that such a case existed?
Yes, sir.
Okay. Has that case been closed out?
I am not sure, sir.
Okay. Ms. Harrison, do you know?
I do not.
Okay. Do you know? Has that case been closed out?
Not to our recollection, no.
Okay.
Which one, the other one? that
The
they-
other
for
one,
the building?
because
and
this
the
is
people?
case number 1522 that's here today.
They sent a letter but they had the wrong date on the letter
Mhm.
for
For next year.
for next. yeah,
Another
but
hearing.
For
Mhm.
another hearing in the citrus, in the
It's not the wrong
county.
date, it's just, I'll be presiding over that one in January, I believe.
Of 2025.
But it says 2025.
Oh, okay. Does it make sense to you that it probably is 2026?
Yeah.
Of
All right,
course.
all right. So you're on notice, whatever it
course,
is.
yeah.
All right, so I'm reviewing the letter. What is the county's position on the defense that's been made?
At this time, the way I've read the statutes is even with the aquaculture certification, they do not qualify for the agricultural exemption because they are not qualified as ag land under the property appraiser's website with the way the statute is written. The other statutes that they referenced with regards to farm buildings, fences, and signs is not relevant to today's case because this has nothing to do with a building, a fence, or a sign. So the only portion of the statute with right to farm that would be possibly applicable, you have to be recognized having an agricultural exemption under the property appraiser's website and being classified as an ag classification in order to qualify for that statute. They do not at this time have that qualification, so therefore that exemption does not apply despite them having the certification from the state that they are aquaculture, which does qualify as agriculture in the state of Florida. So unfortunately for them, even though aquaculture is agriculture, they don't have the agricultural exemption for the classification that is necessary to qualify for the Right to Farm Act. So they do not get those protections afforded by the statute.
Can I add something?
And there is
Come on,
not a building or anything else to qualify for the secondary statute.
Now, if they did,
If they did which part?
well, I mean, I think you're saying if they had the exemption from the property appraiser, would it then qualify?
Yes.
So if I gave them 90 days to get it and they got it, this case goes away.
Correct.
That's the county's position. Now, what is your position?
Well, the thing is, property appraisal and like development is completely separate categories. What you're talking about is sales receipts.
If you would, address me instead of the attorney.
Okay.
Yeah.
What's being talked about is sales receipts and things that you would need. You'd have to have like history of sales to get an appraisal for that property. Where the the certificate that we have right now is to develop. We're developing. We can't have sales if we haven't finished construction and we haven't, you know, got any sales. So that's why the state of Florida gives us that certificate to allow us to, you know, finish our project.
So you're saying you can't qualify the way she says unless you actually get to complete building what you're doing?
I would need a year of history of receipts and, like, you know, proof that I'm actually like running something to qualify that. They're basing everything on their system, which is they caught it because it's like not appraised, like tax-wise. But in actuality, the state and the county, they don't work with the same system together, so they're kind of like working against each other in a way, not getting the right information or all the information.
What are you using the fill dirt for?
The fill dirt was for the tanks that are going to be structured, so it's crucial for like the tanks that are going to be placed there.
Okay.
There's another, let me see, like Florida Statute 163.3162, the Agricultural Lands and Practices Act protects bona fide agricultural operations from duplicative regulation by government entities. It prohibits governmental bodies from creating rules that restrict or limit activities on farmland, although it includes exceptions for certain areas like the Everglades or for specific environmental regulations like stormwater management in some cases. Also relevant is that the Florida agriculture, they use something, I'm not sure what it is, it's called best management practices, and you need to follow those best management practices or show evidence that you're going to follow it, so before they give you like a certificate.
I'm not a master of these statutes, and unfortunately, for both sides, I'm not going to issue a ruling today. I'm going to continue this hearing to the next month so that I can research this on my own. If you want, I'm not going to issue a separate order on this, but if you want, you can submit a briefing. I mean, you know, basically this has been briefed by the respondents. It has not been briefed by the county. But if you want, you can supplement your brief. The county can give me a brief no later than 1 week before the hearing. Okay, so the next hearing is going to be, are we doing one in January? Okay. Oh, because I'm not, I won't be here. I'm sorry, December. Okay. So the December hearing, let's get a date. I mean, what's the actual date? 12/19, December 19th?
12/17.
12/17. So I'm continuing this to December 17th, at which time I will issue an order. You can give me the benefit of further briefing so long as I receive it by December 10th.
So in layman's terms, just send you like our evidence?
It's up to you. No, I don't want evidence. I want legal, whatever you think will help me make a decision based on the statutes. Make sense?
Okay.
Ms.
Thank you.
Harrison?
Yes.
Makes sense?
Yes.
Okay. All right, thank you. It's continued.
Thank you.
Thank you.
Next case, Jeremy Suarez, case number 2025-1477, Code Officer Erica Olson. Page 35 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Good morning. I do. Jeremy Suarez.
Victoria Linderbeck.
Okay, good morning.
I'm sorry.
All right.
Erica Olson, Citrus County Code Compliance Officer. This is case number CE 2025-01477, a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. They own 2 lots next to each other. One has a home on it. This one does not. It's considered vacant. And they have taken down quite a few trees and brought in dirt to kind of make like a circle driveway.
So that's the county's case. So this is where I turn to you. You've now sat here through a bunch of these, and I ask you, are you contesting whether or not there's actually a violation? Are you?
No, I took out trees and we brought in dirt because there was erosion issues, and we actually have a building permit because we're putting in a 24 by 36 pole barn on the property in the area where we brought in the dirt.
You have a permit?
It's pending at this moment.
Okay. So you do not have a permit, but you've applied for one.
Yes.
And when did you apply for one?
We had to wait till our survey was done, which we didn't realize was gonna take like 6 months.
Yep.
We applied for the building permit on October 21st.
Okay. All right, I'll let the county proceed with its case. I'd like to hear what you have to say.
Address is 8101 West Chaskawitska Street, Homosassa, Florida.
Wait, what's the address? 8101?
Or, I'm sorry, 8108, I
Okay.
apologize. West Chaskawitska Street, Homosassa, Florida. It's approximately 0.62 acres, vacant, zone CLR-MH. Property owners, Jeremy Suarez. I have good service via signed certified mail return receipt. I'd like to authenticate the following documents and request that they be admitted into evidence. Photos taken during my initial inspection on the 22nd of August, 2025. Photos taken during my corrective action inspection, the 10th of September, 2025. And photos of my pre-hearing inspection on the 17th of November, 2025. Exhibit B, a copy of notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the certified mail return receipt.
All right, can you show the documents to Mr. Suarez? And sir and ma'am, let me know if you have any objections to them being evidence in this hearing.
Nope.
I don't think there's a lot of dispute on what
Yeah,
actually
that's our
happened.
property.
Yeah.
This is just everything was sent to you.
Okay.
Thank you. Without objection, what's been proposed as Exhibits A and B are evidence, and I'm just going to take a quick look so I can understand. By the way, when y'all are digging out there in Citrus County, watch out because things are flooding, things are falling into ponds, and it's, listen, I'm hearing things. Despite my best efforts. Okay. All right, let me just look at Exhibit B real quick. So I want to ask Ms. Olson.
Yes, sir.
So on the notice of violation, the following corrective action must be taken by September 8th, 2025. Obtain building permit or site development order. To the best of your knowledge, did they do that by September 8th, 2025?
No, sir.
Had they done it, would this case have abated?
If they got a permit, yeah, it would have abated.
Okay. So the issue here, I mean, you've already heard what, you know, their case is. Have you had conversations with them?
Not with Mr. Suarez. I have spoken to his wife, and she said, you know, they didn't know. They're from Hernando County. Hernando County, you don't need to do that. This road is like right on the border of Hernando and
Oh,
Citrus.
really?
Yes, sir. So it was just, she seemed very apologetic. She's very nice, so.
All right, well, I mean, first let me ask this before going to Mr. Suarez. Is there anyone from the public who wants to be heard on this case? Okay. Is there anything else you want to say about it? I mean, I don't know. The issue here, of course, is that it looks pretty clear that the trees came down without a proper permit.
Yeah, we took down trees. Since then, we've joined the lots like we were supposed to.
Unity of title,
I've already paid
or-
for, yeah, unity of title. Yep, I've already, like I said, we're waiting on the,
We're waiting on the survey.
yeah, the survey.
Will the county issue a permit while this case is pending?
They don't have unity of title because that would be part of a building permit. So the case pending would be something where we'd cite them for after the fact, but we could issue a permit and they could do unity of title when it's issued.
I mean, they've said they have something pending now. What do they have pending?
This right here.
Yeah, I couldn't find, it. Yeah, that doesn't count until the permit's issued. That's nothing. I couldn't find a permit. I'm not questioning them. We have a new system and I may have missed it, but
That's okay, then I want to see what they have. I mean, are you prepared to give me a copy of what you have?
Yeah.
I mean, it's not an original of anything, right? It's just a printout.
These are the original.
the permit application, did you get a receipt or anything or
We
print
got
out?
the building permit number.
You have a permit number? Okay, we can look it up, but most likely it's what he had said, a
Can you
garage or
read the
something.
number into the record?
Yeah, the building permit number is BLD 2510-1041.
That sounds like a building permit number to me, but I don't know.
Yeah, it seems like it might have an extra digit, but I'll check it.
Okay.
Absolutely.
Okay.
I'm not doubting that they might have
Yeah.
applied for something
Right.
and they can get it, and at that time, unity of title can kick in.
Does the county take the position, well, what does the county want in this case?
Asking for a one-time fine of $1,500.
A 1,500?
Yes, sir.
Wow, the county is giving you a Christmas special. I know it doesn't sound like that, but you know, they normally ask for $5,000. So why not higher? Not that I'd be inclined to, I'm just curious why.
Well, initially, when I wrote up, when I was thinking about this case, I was going to ask for more. But I do think that it really was an accident. I think that when you look at the aerial, I couldn't tell exactly like how many trees were cut down and if they're going to get their building permit. I just think that $1,500 is appropriate.
Is there anything else y'all would like to say?
No, I mean, we've already paid for the pole barn. We're just waiting on paperwork, really. It's the only thing that's holding us up from everything.
I am going to issue the $1,500 fine, but it will be that one-time fine. That's about as low as we go. And wish you good luck.
Thank you.
Next case, George David Ignaton, case number 2025-1877. Code Officer Julie Wilkinson, page 16 of your agenda.
Good morning. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you
Yes.
both state your names, please.
I'm sorry, what did you say?
Would you state your name, please?
George Ignaton.
Okay.
Julie Wilkinson.
Okay, welcome to you both. All right, Ms. Wilkinson.
So this is a repeat case for an overgrown lawn. The property, it has abated, and has been abated for a while now. That's basically where we're at.
Okay. Can you, I'll let you go through your case. I mean, I would like to see the exhibits and
Yes, sir.
we'll go from there.
Okay, this repeat case initially observed on October 17th, 2025. The address of the violation is 1685 North Prospect Avenue in Lecanto, Florida. The case, the property is 1.11 acres and zoned to LDR. Property owner is George David Ignaton. He's been previously found guilty of the same violation at the same property on October 19th, 2023. That case number is CE 2023-00709. That case was abated on November 9th, 2023 with $0 in imposed fines. I have good service via posting on the notice of hearing at the property and the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, the findings of facts and order acknowledging compliance from previous case, CE 2023-00709. Exhibit B, photos I took during my initial inspection on October 17th, 2025. Photos from subsequent inspections on October 23rd and 29th, November 6th, 13th, and the 18th. Exhibit C, a copy of the notice of violation and hearing sent to George David Ignaton a copy of the posting affidavit, a photo of the notice of hearing, notice of violation and hearing posted at the property, and a copy of the general pre-hearing
When
order.
did the violation abate?
He mowed it. The grass got cut.
When?
Oh, sorry. It abated on October 29th.
So you've got about, what, 12 days
Yes.
of violation? Mr. Ignatin, does that sound about right to you? I mean, did it get over 18 inches again, or?
It's approximately correct, because I wasn't writing down dates and when I did it. I have an electric mower that I use, and I had a series of weird things going on. One of my electric motors died. So basically, I mow my lawn in parts. I can only get 10 to 15 minutes from each battery. And so I went from 25 minutes down to 12 and a half minutes or so, and I'm mowing around. And also my lawn is a giant sponge. So I'm not the top of the hill, so I'm about 3 houses down, and I have incredibly wet ground. So I can't mow when it's raining, I can't mow in storms. And I was keeping up in part, and I have a person who comes and mows about every 3 weeks with a big mower who comes and gets over the whole area. And his car broke down, and his trailer broke down with his lawnmower. So we had this, you might call it a comedy of errors, but it was just a thing. So I'm mowing around it. So when it's the 29th, I would say it was probably a week before that, but I could be wrong. And one of the things I'm doing is that the northern section of the property has almost no grass at all. And I've been trying to seed, I put seed and grass down, and I've been trying to grow the grass. And I'm not an expert in botany, but it seemed to me that it was that's the way to get the lawn to grow back, is to let these shoots grow up, reseed, and then go down and redo the lawn. So I had planted seeds, and I had taken care of some of
Gosh,
the
you
weeds.
just missed him, but Mr. Novich was here earlier, and you could have talked to him. He's good at that. But go ahead.
Well, as I say, I'm not an expert in botany, although I did take a course in it once upon a time, before you were born.
Well, I don't know. I don't know about that. But maybe.
But it seems to me that that's the way to get it to grow. And I'm like the 6th owner of the property, and the lawn was a wreck when I came to it, and I've been regrowing it. And to give you one example of the kind of thing that I do is I have a depression in the lawn where the lawn essentially goes like this. And
Can I see pictures? Can we? I'm curious to see, sir.
Well, you can't see it because I've covered it up.
Well, we'll see. We'll see. That's why I want to see the pictures. Do you have any objection to the photos that Ms. Wilkinson took?
No, that's
seeing evidence.
Yeah, if you take a look at this picture, this is kind of an interesting picture. If you have a before I moved in, an awful lot of stuff is not there. So, like right out in front, these are my butterfly bushes, which I have done, and
you're pollinator friendly.
Well, this is a nice picture. I don't see a problem with this.
Well, that's why I want to see the photos. So let me know if you have any objection. I would like to see the photos.
Okay, like I say.
And what is the county's recommendation ultimately going to be?
Yeah, so basically what I do is
$150 a day for 12 days.
Yeah, so basically, it was getting long in several areas.
Thank you.
And the guy, as I say, who comes and mows like every 3 weeks, could not come because of his broken car. And then he went and bought a new one, and so somewhere in the range of, let's say, October 25th, give or take 3 or 4 days, as far as I can tell. But that was, but I was still working on it. And
Yeah, you know, I mean, I see what you're trying to do. It looks very nice mode. So wait a second, why, you didn't abate it on the 23rd?
No, because not all of the lawn was.
Oh, I see, I see. Hence, the fact that you were mowing it in pieces. Yes, I see, okay.
Yeah, so I've got a driveway and they're separate
There's
pieces.
something to be said for the old gas-powered mowers.
Well, there's something to be said for the electric mower too.
Not in this case. And even a weed whacker, you know, could have done it.
Well, my standard argument is what I like most about my electric mower is that it quits before I do.
I love that.
Unfortunately, you know, this would have been a really easy case, you know, for you. And you're in a situation where now there's not just been one, but two violations. Like, this is a repeat thing. You're going to have to do what it takes to make sure this doesn't happen again.
Yeah, now the first violation was kind of a technical violation because I missed, I didn't show up for it because
I knew before I even saw it who the officer was. Can you guess? Can you guess, Mr. Charlton? Amy Becker. And she had the best kinds of these because, you know, she knew right where that line was. I understand it may have been technical, but it was a violation. I presided over it. I remember it, actually. So look, here's the issue. I'm going to find that a violation did occur. I'll do $100 a day for the 12 days that it was out of violation. But, you know, that's twice or three times or four times the price of a gas mower overall. So just do what you can to make sure it doesn't happen again. And it's a beautiful property if you can keep it that way. All right?
Okay.
Good luck.
Thank you.
Next two cases, Crystal River Methodist Church Incorporated, case numbers 2025-1356 and 2025-0736. Code Officer Cody McGuire. Pages 9 and 10 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Good morning.
Beth LeBrandy. Mary Thomas.
Okay, great. Good morning.
Good morning.
Mr. McGuire, are you ready?
Yes, sir.
All right.
I'm gonna do case number 2025-1356 first, simply because they brought the property in compliance and we're asking for administrative costs.
This is the LDC 2409 Professional Services Office District case?
No, I'm sorry.
Oh, I'm sorry. The temporary uses case?
Yes, sir.
Okay. So case number 25-736, temporary occupation of a wrecked vehicle. Okay. Tell me about it.
So basically, I was out there taking photos on July 7th. I had seen people going in and out of RVs. I had sent a notice of violation. I've been in communication with Ms. Thomas. Since then, the people have vacated the RV, but since it's simply been the second time this has happened, we're bringing it for administrative costs.
All right. Is what he said, does that make sense? That it's abated, but because this is the second time it's happened, they want me to at least find that a violation had occurred, even though it's been fixed, and to assess the administrative cost, the cost of investigation that they have to do in order to, you know, bring you in from the cold.
Right.
So does that make sense?
Yes.
All right. Is there anyone from the public who wants to be heard on this case? Then I'll do that. I'll assess that there's, I mean, it sounds like you can see there was a violation.
Yes,
Otherwise, I'm gonna have to go through all the evidence. It's not a big deal. I'll go through it. But did you concede that there was a violation of this temporary use?
Yes.
Okay. So ordered. Okay. Administrative costs.
Okay, thank you.
Let's talk about the next case.
2025-01356, Land Development Code, Section 2409, Professional Service Offices District, PSO. The address is 5015 North Citrus Avenue, Crystal River, Florida. The property owner is Crystal River Methodist Church Incorporated. Goods service be assigned certified mail return receipt. And then I'd like to authenticate the following documents requested to be admitted in evidence. It's going to be photos taken during initial inspection on July 7th of 25, photos taken during a corrective action inspection on September 30th of 25, and then my final inspection on November 17th of 25. And then Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, and the signed certified mail return receipt.
Okay, so Ma'am and ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
These were included in all my original photos.
That's fine.
It's just saying that it was there and it's there.
Okay.
And then that's the mailing that came certified. The
Okay.
hearing, that's the copy of the certified.
Okay.
And then the pre-hearing order is the last 3 pages.
Okay. No problem.
All right, so without objection, I'll receive the exhibits. What I'd like to ask from you, Mr. Guire, is to tell me just kind of a narrative of what's going on.
So right now they are operating a thrift shop in a non-zoned area.
I see.
Unpermitted area, I'm sorry.
A thrift shop, so it's not a permitted use in this zoning.
I'm jumping in, I'm sorry, land development. It is a permitted use in PSO, it could be. And staff have been working very much with these, they're very trying, but they don't have a permit yet for the use. It was permitted as a church tabernacle back in 2001. Sometime since then, it became a thrift shop food pantry and now a thrift
I
shop
see.
without permits.
I see.
They're gonna have to go through some, they don't have any paved parking, there's some issues, but we certainly work with them. They've seemed very willing to try to fix this, but.
You haven't closed the door on that use in that location?
It's not something that the building official would feel is warranted, but it's not a permitted use at this time.
Well,
Yeah, I mean,
I
I
have
don't think
to
it's a
choose my
danger.
words carefully
Yeah.
in this.
Yeah.
What I mean is, you are not closing the door on them being able to actually do this permitted use in this site. It's something that may be doable once some hoops are jumped through.
Absolutely. It'll take some time, though, and they know that, and I think they're working on the engineering, which is one of the bigger ones.
Okay, all right. Well, then, in that case, I'd love to hear from the church. I mean, it sounds pretty clear cut. Have you heard anything that you disagree with?
No.
Okay. Do you have any idea of how long it might take?
I estimate, I think 6 months.
It's hard
3
to
to
know.
6 months. We started in, we got an agreement for, we did our pre-application with the county on September the 9th.
Oh.
The church voted to authorize the funds to make the improvements on October 12th. We had agreement for professional services by October 13th. We have a letter of authorization with SwiftMud allowing our engineer to work with them on October 13th. We've been invoiced by the engineer once, and we have performed our geotechnical services for the drainage retention area, and we have their report that was done by October 28th.
Why do you need a drain? Oh, for the parking or?
Drainage.
Okay, okay.
And we have the field work for the survey was completed on November the 7th, and that is the major holdup right now. The field work's been done, but the drafting and the map has not come in for the engineer, or everybody's waiting on the survey to move forward. So it's taken us, almost 1 month just to get through that part. So we are trying to move forward. SwiftMud has a date of December 28th where they're going to be changing some of the water quality rules, and we're trying to get that done before that.
So that you don't have good water quality?
No, I don't know. I'm just.
I mean, you're trying to beat the improved standards for water
yes.
quality? Okay.
Yes. Everybody's trying. That's something I think everybody's trying to do. Not
I'm
just
sure.
me.
I mean, that's the way it
New
works,
rules,
I guess.
new
That's
regs,
right.
new money, additional
Okay.
funds. So yeah.
What
that
is the next? So the next step is to get a survey?
No, we've already done the
Oh, you got
field
the
work.
survey.
We're just waiting on the mapping.
The
draft-
mapping?
The drafting.
Oh, the drafting.
Yeah, so we're in a queue to have our project done, but the field work has been done.
From the county's perspective, what is the next step for them? So I want to tell you what I'm thinking. I think that instead of just giving blanket 6 months or 8 months or 10 months to people like I have done in the past, I want to put milestones. That certain things need to be met by certain times, otherwise the extra time won't be granted. I think we've had too many cases, and I'm not saying you would, but we've seen a lot of cases where people don't do anything even in 10 months. So I'd like to see that.
Yeah, agreed. That's a very, very good point. Perhaps submitting an application within 6 months and keeping it active. So by keeping it active, they'll have to continuously, they can't just drop it then.
Okay.
Which seems to have happened in the past, not with these particular people. And thank you, I did misspoke, and the building official, I can't speak for him, so you're right, but
No,
you're good.
Well, you actually directly addressed the question I asked, and I
Yeah, but
realized I didn't ask
shouldn't
it
have,
clearly.
I'm not him.
No, okay, so I like that recommendation, and then, so 6 months and keep it active is something that
Right, a
you all can
complete-
follow as an objective standard.
A complete permit application for 6 months for the thrift shop, and then keeping it active, which would require either an inspection or constant
I think that's
reviews.
reasonable. I like that a lot. Okay. That makes me feel better about these kinds of cases going forward, where I don't just give a blanket huge amount of time with nothing. So, Mr. McGuire, what's the county's recommendation?
That was $50 a day.
Okay. Is there anyone from the public who wants to be heard on this? No one's coming after the Methodist today? Okay, well, geez, no longer as persecuted as they used to be. I'll give 6 months. I will find a violation, 6 months to complete an application, okay? And then have to keep it active thereafter. If it doesn't stay active, then a fine of $50 a day will occur until it's completely abated. Does that make sense?
That's
Legally, I have a question. It kind of leaves it open, because technically, if they have the building permit, as long as they ask for an inspection every 6 months, they could really keep this open for the next 5 or 10 years.
Do you just keep it open regardless of whether the inspection
And
makes sense? I mean, you all don't administratively close it if it's just like nothing's happening? Can it be gamed like that? I mean, I don't know.
Yes, it could be gamed like that. If they come in and ask for an inspection every so many months, that's what keeps it active. And now granted, you could fail your inspection and you have to pay the cost for failing your inspection, but in theory, that leaves our code case open where we could not close it, we could not do anything if somebody chose to game the system that way for 5 years maybe.
Well, then I will put into the order that upon request, we can revisit the order at a hearing. If the county is not satisfied with the progress, I will revisit it.
So what is, can we have in the order that if the building permit is issued, our case can close?
For sure.
Okay, thank you.
She just gave you the roadmap on how to game the order, okay?
Sorry.
But I'm saying that if the county's unsatisfied with the progress, they can at least come before me. You can explain if you have a good excuse, but.
Right. Because I did speak one time about going ahead and applying for the permit, but it was like, well, no, we don't want to hold it in queue. You need to wait till you have your,
You have
all
6
your
months
documents.
to complete the application.
Okay, well, that's fine.
Which I think is a very good amount of time. To complete the application.
Yeah, submit a completed application, I
Yeah,
think
no,
is the
to
formal
have a
wording.
complete application. It's not one that needs to come back with comments. It's not one that is incomplete. It has to be a complete application.
Submit and complete within 6 months.
Submit a complete
Yes.
application
So
within 6
submit
months.
it before that, because it probably will get kicked back.
You
There's
know all the
always
documents
issues.
that you need, just turn those in
Okay.
within 6 months.
If there's any issues, feel free to bring the order back. We'll talk about it. All right?
We want to thank you so much. It is our intention to do everything that we can to make this right.
Yeah. Good luck.
Thank you.
Thanks.
Next two cases, David F. Plante, case number 2025-1440 and 2025-1441. Code Officer Alan Jonason, pages 28 and 29 of your agenda. Expert on the case for 1441 is Land Development Director Joanna Coutu.
How are you? Morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Will you please state your name?
Jeanette Rogers.
All right, now, Ms. Rogers, we're here on 2 cases where I see the respondent as being David F. Plante. Are you an occupant or tenant of the property?
David Plant is my father who's
Plant.
deceased.
Okay, so are you an heir of David
am.
Plant? Okay. And well, that answers that. Now, I noticed that your shirt says God don't play. Do you know if the Methodists agree with that?
I don't play.
Is that a religious doctrine of any particular?
It's
just
I'm
a
not
message to me, and
I'm a
I
new-
agree.
I'm a new Christian under
Oh, well,
construction, trying
congrats.
to move
Okay.
forward, you know?
Okay. All right, so Mr. Jonason, it's on you.
Sure, I'd like to do the junk case first, and then we'll do the other one. Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-01440, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 4141 East Alabama Lane, Hernando, Florida. Property owner is Plante David F. This property is approximately 0.17 acres and is zoned CLRMH and was purchased on 1 June 1999. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 26 August 2025, follow-up photos from my inspection on 27 October 2025, and photos from my final inspection conducted on 18 November 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing order.
Before we get into it, what's happening on the property?
So two things are happening. There's two goats on the property, and she has explained to me that the junk that we are saying is junk, she's using as shade and things like that for the animals. Unfortunately, I explained to her that she couldn't have a camper shell unless it was on a camper or inside of an enclosed building.
How big is the property?
Approximately 0.17 acres.
0.17.
Yes, sir.
And there's one goat.
Or a goat.
What happened to the other one?
Someone poisoned it.
Wow, okay, well, all right. Can you please show the proposed
Sure.
exhibits?
These are for the junk case.
Yes,
Okay.
to Ms. Rogers, and we'll go through it.
Did you come by yesterday?
I did.
Okay. So you saw that all the stuff was.
Again, these are dated. You can see the dates up.
Okay. So those pictures aren't current either.
They're not, these are not real photos?
They're not current.
They're not current. I thought you
Yes.
said they weren't correct. I got you.
Yes.
All right, well, first let me take a look. I'm going to admit them as evidence, as exhibits A and B. I'm looking, but let me look through it. I mean, it's, I see the issue. Do you know who poisoned the goat? No?
Mm-mm.
Do you have suspicions?
Yes, but if I knew exactly.
Will you be seeking retribution?
No. You guys would probably be seeking
I
a
tell
bond
you,
for
boy,
me.
times have changed. Let's see. All right, please proceed if you have anything
Sure.
else.
I'm going to read this with the Lanza case in it, my dialogue here.
Fair.
If that doesn't
get it.
confuse you. On 26 August 2025, I conducted my initial inspection and observed the property to be in violation of junkyard conditions and Lanza with 2 small goats and a camper shell, pallets, tires, tarps, and construction debris on the property. On 26 August 2025, a notice of violation was issued for livestock animals in a non-zoned area and junkyard conditions, which is a violation of the ordinance I mentioned earlier. On 15 October 2025, it was determined that there was enough acreage for the property owner to keep the goats, and a notice of hearing was issued for both cases, the junk and the livestock. I have had contact with.
Did you just testify that there was enough acreage for, or there
Was not.
Okay.
Was not.
Misheard you.
Sure. I have had contact with the property owner, and as of my final inspection on 18 November 2025, the property remains in violation. Land Director Joanna Coutu, Land Development Director Joanna Coutu is my expert on the case, on the livestock case.
Okay. I'm just looking at the code section. What is the acreage requirement for goats?
You can't have goats.
You just can't have them, period?
No.
I was told it would be an acre is what I was told.
It's the CLR district, so she would need 2 acres, and then 1 goat per acre is the land development code.
So if she had
If
2
she had
acres,
2
she could have
1
2
per acre.
goats?
Yes.
Okay. All right, Ms. Rogers, does this make sense to you? So my question, we're just talking about the junk case right now.
Junk case.
It's
that's
not,
all.
it wouldn't take you long. I mean,
And
it
it's
would
done.
take you, it's done.
If he would've came by yesterday, he would've saw there's a huge dumpster. I've been accumulating. The big tractor tire that he's talking about is for the agility of the goat. The camper topper with the pallets, we had discussed with him that we were making a shelter, so in case it rained or was hot or sunny, that the animal could go into while it was outside. That was all discussed prior.
Okay. And so I'm not going to issue an order on this case until I've heard the other case, because I think they are intertwined, so.
Sure. Again, photos taken during the same time period, notices issued around the same time period. Again, I saw that the goats were there and issued the notice of violation. Now, in the last 2 times I've taken photos, I have not been able to take photos of the goats. I believe they're in a pen. She indicated to me through telephonic communication that she was keeping the goats and wanted to go to hearing. So that's why we're here. But yeah, absolutely.
All right, I mean, does it make sense, Ms. Rogers, what the code says? I mean.
The fact that Chewy is an emotional support animal, which Alan sent me information that I need to have that provided to document him as an emotional support animal. I have complied and sent back the information, have sent follow-up emails, didn't hear from Alan for over a month. I thought it was all resolved. I didn't know anything was going further. But as for, he's got plenty of land to run on. He's got plenty of hay. Goats don't eat grass. They eat forage. They eat hay. He gets fed twice a day. And he came from a PTSD farm, bottle fed, that I interacted with for months before I received these goats, for reasons of how he is an emotional support goat. Which I have here.
What is?
I was told in my letter that I had to have it on a drive, that I wouldn't be able to bring in documents. That's why I was kind of surprised today to see people with documents. But I have a letter from my physician, as well as the farm that Chewy came from.
Okay, that's on the thumb drive?
Yes. And, well, I do have there's some pictures of the habitats of Chewy, how he interacts with me, what he eats, the fact that he won't touch the grass to eat. People allow their potbelly pigs to come in and outside of their house, but I can't allow my goat. Dogs live in 10 by 10 pens, but my goat lives on the whole acreage unless I'm with a whole lot of land, unless I'm at work.
I think you're making a good point. I mean, but the problem is what the code says. I mean,
I got that, but
they're treated differently under the code, whether that's right or wrong, And in order to change that, you have to talk to your county commissioners. The people who really sit here to change the law. I mean,
but I can get a pig and let it come in and out of my house, and it's fine.
I'm sorry?
A pig instead of the goat. It would be a
I don't know about
pig.
a pig off the top of my head, but
that's not something that would be.
It's a compelling point to me that how dogs are treated versus how goats might be treated, but I don't write the code. So let me see here. I'm just reading.
And I don't know if the letters were put in with his documents regarding Chewy that I emailed back to him after he told me he doesn't communicate through email. Everything has to be verbal over the phone.
So what my order, my pre-hearing order says in section 9 is videos and photos should be presented on a USB drive for deposit and playback with the tribunal, or printed out in the case of photographs. So I guess maybe we can be a little more clear about that. Okay. We had a case like this recently where I was called to. Yeah.
She has a copy of the letters if you.
Oh, I do want to see it.
I do have a copy
I'm
of the
sorry,
letters.
I do want to see it.
Just not the pictures of Chewy
No,
interacting.
that's fine, okay.
Yeah,
I
just not
assume
the pictures and videos
I
of
take as
Chewy.
granted that Chewy's there, and
There was 2 in the beginning.
I understand. Thank you. Thank you for pointing that out. All right.
In
so-
a week's time, code enforcement came.
Hold on, Ms. Rogers, if you would.
As to the statutory requirements for ESA, I don't know that the letter from the farm has any relevance.
Okay. All right, let me review it. How old is your son?
31.
Are you sure you want to have this? Do you need a tissue or okay. Are you sure you want to enter this Healing Hearts Farm, into the record?
Yes.
Okay, it's going to be a public record, just so you know. All right. Here's the legal issue, Ms. Rogers. It has been litigated in the state of Florida the extent to which an emotional service animal can exempt you from application of the code. And there are situations when that can happen, at least according to a case out of Miami that I presented here, I think a few months ago. But what that case said is, in order for an emotional support animal, ESA, for an ESA, let me just say that, to exempt you from the code, there has to be evidence that says, basically from, you're halfway there, but there has to be evidence from the medical letter that the ESA is necessary for you to be able to live in the home, to actually be able to move around in the home, like to enjoy the same benefits that most people do inside of a home.
Chewy?
That Chew would have to do that for you.
He does. He comes inside.
Yeah, but that's not what the letter says. And so there has to be evidence from a medical professional that says,
Okay.
what this says is you require an ESA for management of chronic conditions. I have no reason to disbelieve that. I love goats, as the county knows. I think you should be able to have goats anywhere you want. Neighbors don't always feel that way, and that's why the code is written the way that it is. So the evidence you provided is relevant, but it's not enough, because it doesn't say that you need it for the home. Now, that said, I think the letter provided from Healing Hearts Farm is very persuasive, and I have no evidence to disbelieve it. So here's your situation. I am going to find that it's a violation of the code. You have a choice. Either I'm going to give you sufficient time to make preparations for the goat to either be relocated or for you to relocate. I'm going to give you what time you request. Alternatively, you can just live with the fine on the property and hope the county doesn't foreclose. That's the situation you're going to have. So how much time do you need to fix this situation?
With Chewy?
Mm-hmm.
Only God knows that, baby.
I'm sorry? Only God knows that?
Till my dying day.
Well, what I mean is, if you told me that you need 60 days or 90 days, that's the time you get to abate the violation. Does that make sense?
Mm-hmm.
How much time do you need?
You like goats? You want them? And we could take care of this today.
I do, but guess what? If I take them, then I get the same case that you have before you, and I appear, I'm dead serious, in a much harsher code environment, let me tell you. The city of Orlando, listen. You get 7 days on everything in Orlando. So I'm asking you, how much time do you need?
I'm thinking 45 days.
I will give 60 on both cases. What's the county's recommendation?
$100 per violation plus administrative.
Is there anyone from the public who wants to be heard on either of these cases? All right, so ordered. 60 days in each case, $100 a day if not brought into compliance. And what that means, of course, is you have to fix the goat situation, you have to fix the junk situation. Okay? Thank you.
So, Alan, I need to know when you come by today, what you see. Do you know when? Because I have. Oh, okay. So what does that mean? Don't they come out and?
Next
Ready
case.
for the next case?
Yep.
Next case, Matthew Roberts O'Shell, case number 2025-1672, Code Officer Julie Wilkinson, page 25 of your agenda.
Matthew Ozell.
Good morning, sir. And how do I pronounce your last name again?
Oshal.
Oshal? Oshal, okay. Please proceed.
Yes, this is a lawn case. The lawn was overgrown in excess of 18 inches. He did cut the grass. However, what remains now is two piles of accumulation of vegetation that need to be removed.
How does it feel? I think, are you the last one called?
Yeah, I think so.
Did they save the best for last?
I guess so.
Okay. So what Ms. Wilkinson has said is, I guess this started out having two different types of violation under this code section. Accumulations of vegetative matter.
Yeah, well, the overgrown lawn and the accumulation of vegetative matter is in the same code.
No, I know it is, but there's two different, you can cite someone under the same code for two different things. And so you're saying there's accumulations and it was overgrown.
Initially, there was no accumulation, just the overgrown.
Okay.
Now there's the accumulation that happened after he
What's
cut
the
grass.
accumulation?
Tree debris and weed. He had weeds that were like as tall as me, and they're just in a pile on the ground where they were cut.
Okay. Does this make sense, Mr. O'Shell?
Yeah, the reason why I haven't gotten rid of it yet, there's a burn ban currently in the county, and I was gonna burn them, and I haven't been able to do that yet for that reason. Also, or I would have to have them hauled away, and I can't afford that.
How big's the pile?
It's not that big. I took down a bunch of branches. There's a pile in back, there's a pile in front, and then there's the weed she was talking about.
I mean, do you have a garbage can or anything? I mean,
no, not big enough to fit it, no.
okay, all right. Well, how much time do you need to?
I won't have the money to get it removed until after the 1st.
Of December?
Yeah.
I mean, and what is the burn ban situation? I mean, I thought that was regulated by.
It's regulated by county code. Once it hits a certain number on the scale, I think it's 450, code allows the marshal to be able to implement an automatic burn ban, or the fire department, which they did, I believe, last Sunday. It's within the last week and a half. Once that number comes back down and can safely come back down, then the burn ban goes away.
So I'm not an expert in this, but are you saying that even if, I thought this was more regulated by the Forest Service, but.
No, it's county ordinance.
Okay. What's the county's recommendation?
It's going to be $50 a day along with the administrative cost because he did make an effort.
Yeah. Is there anyone from the public who wants to be heard on this? I don't see anyone else from the public, so I won't be asking for the public anymore. Look, today is the 19th. Normally, I don't grant much time on these things, but due to the cooperation and abating the other stuff, I will give you 3 weeks to abate the violation. And if it's not brought into compliance as ordered, $50 a day.
Thank you.
All right, thank you.
Thanks.
Next case, Marin Dorel Borigano and Ismaray Pilat Gonzalez, Code Officer Cody McGuire. Case number 2025-1739, page 6 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Cody McGuire, Citrus County Code Compliance Officer, case number 2025-01739, trucks parked in selected land use districts, violation of Citrus County Land Development Code 3320. The address is 5829 North McCree Terrace in Christopher, Florida. It's 5.45 acres and it's zoned RUR. The property owners are Durrell, Moraine, Barron.
I can see the name.
All right, thank you. Yeah. And then good service via posting the notice of hearing on the property and at the Lecanto Government Building. And I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photo taken during initial inspection on September 23rd, subsequent inspection on September 29th. Photos taken during a corrective action inspection on October 14th of 25. And then photos of my final inspection on, I didn't put it down, the 21st of 25. And then Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the general pre-hearing order, a copy of the notice of hearing posted on the property, and a posting affidavit.
With no other defendants or respondents here, I think for all the cases going forward, just tell me the narrative of what's happening, and then we'll introduce exhibits to justify the findings. Okay, so tell me what's going on.
These people were parking semi-trailers at their property. They weren't aware that they weren't allowed to do that.
You had contact with them?
Yes.
I mean, when did you start this case?
I started this on September 23rd.
And is it still in violation?
No, sir, it came into compliance.
Oh, it did?
Yes.
So you're just seeking costs?
Yes, sir.
All right, what are the costs? Do you know?
Just administrative costs.
Okay. If let's introduce the exhibits then, I'll take a quick look. I'm just curious. Without objection, exhibits A and B are evidence. I do take your word for it. I just want to see. They were living out of that?
No.
Oh, they were
using
parked in the, okay, gotcha.
Yes, sir.
This is where I start to fade without coffee, so let's see. Okay, so ordered.
Thank you.
Well, I do drink coffee on the way. I don't have enough. I mean, I'm already through it. I know.
Next case, Efren Cruz, case number 2025-1599, Code Officer Cody McGuire, expert on the case, Joanna Katu, page 8 of your agenda.
Cody McGuire, case number 2025-01559, special requirements for all accessory structures. The address is 11708 North Belusi Terrace, Denellen, Florida, 1 acre, zone CLR. The property owner is Efren Cruz.
What happened?
He's got a shed, a Connex container, and it's a huge tent. But he's also got a permit that he applied for a conversion from a shed to a home. It just hasn't been issued.
Did he apply for that during the pendency of this case?
On November 5th, so it would have been after.
The answer is yes. Okay, and so have you had contact with the owner?
Unfortunately, no.
What's your recommendation?
This one's $200 a day.
I do need to see the photos then, just to figure out the time. Thank you. What's been proposed as exhibits A and B are evidence, and I will just take a quick look. So the idea for him is to convert this into a livable primary use? Like a residence? Yeah. It's like the Great British Baking Show tent.
What is it?
Yeah, the permit unfortunately is not going anywhere. They need a lot of plans and engineering. It's very, very hard to convert these, and it's not even close at this time.
Thank you, okay. Ooh, boy. All right, well, I'm sorry, what was the county's recommendation?
$200 a day.
Okay, I'll do 60 days, $200 a day.
Thank you.
Next case, Grab Fruit Farm LLC, case number 2025-1723, Code Officer Erica Alston, page 13 of your agenda. Expert on the case, Land Development Director Joanna Katu.
How many cases do you all have open right now? Like at any given time on like how many cases?
90.
Like 300, 200, 100? 300 or 400. That's a lot to keep track of. Okay, just curious.
Erica Olson, Citrus County Code Compliance Officer. This is case number CE 202501723, a violation of Citrus County Land Development Code, Section 4100, site improvement plans. Basically, this house was bought and then he graded the property.
He
And
graded it?
Yes, sir.
Okay.
I don't believe he's brought in any fill dirt. I think he kind of like just dug out and then spread it around the entirety of
Can
the
I see
property.
the photos? If
Yes,
you
sir.
have them? Have you had contact with the owner?
Not the owner. I've had contact with, I don't know if it was the GC or
If you would, to the mic, yeah.
and then I've had contact with the property manager, but not the owner.
All right, what's the county's recommendation?
Recommend $250 per day plus administrative cost.
$200 a day?
250.
250, all right. So exhibits A and B are admitted as evidence. I mean, you took the photos on the dates indicated.
Yes, sir.
But if it's, what abates this?
They would have to get the site improvement plan.
Okay.
No.
All right, this is good. All right, so I will grant, let's see, when did this case start? When did you notify them?
22nd of September was my initial inspection.
Okay, 15 days, $250 a day.
Thank you.
Next case, Robert W. Hufford, case number 2025-1649, Code Officer Cody McGuire, page 15 of your agenda. Expert on the case, Joanna Katu.
Ready?
Cody McGuire, case number 2025-1649, temporary occupancy of a recreational vehicle. Address is 5289 North Summerlin Avenue, Christopher, Florida, 1.03 acres, zoned RURMH. Property owners Robert W. Hufford. Summary, there's multiple people living in multiple RVs on this property. I've had the people that were actually living in the RVs admit it.
Okay. All right, I would like to see the photos. Without objection, what's been proposed as exhibits A and B are evidence, assuming you took the photos on the dates indicated?
Yes, sir.
All right. How big is this property?
1.03 acres.
Oh, I see. Looks like they've got some other issues on this property.
Yes, sir.
Wow. All right. What is your recommendation?
That one's $200 a day.
Has anyone said they're going to do something about it?
They haven't said they wanted to leave.
I mean, have you had contact? You haven't had contact with the owner or any other occupants on the property?
So I can't remember her name, but the woman that lives in the home I did on the previous cases, but I haven't on this one. It's just been the people that have been occupying the structures.
Previous cases that have abated?
No.
Oh, so are there fines accruing on the property?
Mm-hmm.
But for different violations?
A junk and unlicensed.
When were those? They're your cases?
Yes,
they were
sir.
your cases? I don't remember this name. And I presided?
Mm-hmm.
Hufford? Okay. 10 days, $400 a day.
Thank you.
Thanks.
Next case, Judy L. and Christopher T. Liebert, case number 2025-1469, Code Officer Erica Olson, page 20 of your agenda. Expert on the case, Joanna Katu.
Erica Olson, Citrus County Code Compliance Officer, case number CE 2025-01469, a violation of Citrus County Land Development Code Section 4100 Site Improvement Plan. The property is 8438 West Dixie Court in Homosassa. Kind of similar. They did bring in fill dirt. They graded the property, and this property sits on a canal. They've dug down into the property, into the canal.
Whoa.
Yes.
I mean, you have health issues or?
I have not been told that there's any health issues. I did report the canal issues with the seawall to DEP, and there's a case with that.
Okay. I would like to see the exhibits. You took photos on the dates indicated on them. All right, exhibits A and B are admitted as evidence. And I will take a look. I mean, have you had contact with the people on the property?
Yes, I have. They've come in. I've talked to them a couple of times. I've talked to Mr. Labfried out at the property before. He knows how to abate it.
Did he
seemed to
indicate a willingness
understand.
to fix it, or?
He said that he was gonna fix it. He would obtain the site improvement plan.
So the only thing that's needed on this case is a site improvement plan?
Yes, because the state, for the canal issue, it would be a permit through the state,
That's
not by
fine,
county.
yeah, okay. What's the county's recommendation?
I recommend $400 per day plus administrative costs.
When did you start the case?
My first inspection was the 26th of August.
Okay, 10 days, $400 a day.
Thank you.
Next case, Mark Allen Murphy, case number 2025-1816, Code Officer Cody McGuire, page 22 of your agenda. Expert on the case, Joanna Coutu.
You want to run through this one since it's a repeat?
Whatever you want.
I can
Present it how you wish.
We'll summarize it up.
Okay.
Case number 2025-01876 is for special requirements for all accessory structures. The property owner is Mark Allen Murphy, who had been found previously guilty of the same violation at the same location on April 25th of 2024. And that case number was 2024-00821 with $0 in imposed fines. And then abated it on June 27th of 2024 with $0. I can summarize this up now. I have photos taken during my initial inspection on October 8th, my subsequent inspections on October 17th, the 20th, and the 21st of 2025. I haven't been in contact with Mr. Murphy, but I have been in contact with the gentleman that placed the items on the property, and he worked pretty diligently to get them removed pretty quick. He told me that he was going to try and be here, but assuming something happened.
What were the items on the property?
There was an RV, a older four-door Chevy truck, and an enclosed trailer with a little debris behind a privacy
Who's
fence.
responsible?
The person that was responsible for it, his name was
No. Who did you say? You said someone else was responsible.
his name was Robbie.
Okay. And and you have not had contact with Mr. Murphy? Now,
Never, Mr.
in the
Murphy.
prior case, what was the violation exactly?
The same
Well,
items.
What was on the property?
The same items.
It's the exact same items?
Yeah.
Okay. I need to see the photos.
Okay.
That's why I had Robbie's contact information. The Robbie? Let's see. I mean, was he apologetic? Did he indicate, like, gosh, I really screwed up this time?
Yeah. Whenever I spoke to him even yesterday, he said that he's going to avoid this by going and hopefully applying for a permit and putting a home on the property.
Well, he can't. I mean,
He's got a lot of steps.
Yeah, he's got a lot of steps. He's got to buy the property. He's got to get a deed. He's
Yeah.
gotta, that's.
and the reasons for the close dates is he had spoke to me and said things were removed, and then upon inspection, there was still other items, which is why it was back to back.
Well, what is the county's recommendation?
That one is the Citrus County Code Division respectfully requests that the special master assess a fine of $150 a day with administrative costs, beginning on October 8th of 2025, and then continue to the 21st. That's 13 days at $100 total and $1,950.
And from today's date going, oh, it did abate?
Yes, sir.
I see. So how much?
$1,900.50.
Ms. Spiros, can you come up to the mic, please? When is your last day?
December 19th.
So you have one more hearing here. Okay. Now, if you were me, what would the fine be?
$250 a day because it was the same stuff.
Okay, thank you, Ms. Barros. All right, so what I'm more concerned with is the fact that my gut tells me that on a violation like this, and we don't have the benefit of hearing from them, that they just thought they could get away with it again. So it's not acceptable. I'll find that there's a violation and assess a fine of $400 a day for those dates, and I don't know what it comes out to, but that's going to be the order.
Thank you.
Okay, thank you.
Next case, Jill Cassette and Corey and Christopher Paisha, case number 2025-1493, Code Officer Erica Olson, page 27 of your agenda, expert on the case, Joanna Coutu.
I think the Spiros rule will be that whatever, the recommendation is, she would go 100 to 150 more. Okay, so that's, all right. Yeah. All right.
Erica Olson, Citrus County Code Compliance Officer, case number CE 202501493, Land Development Code 3150C, fences, hedges, and walls. Fences, walls, hedges, or other structures or vegetation shall not be permitted over 30 inches in height above the average road grade in the visibility triangle as defined in section 7180, clear visibility triangle of this LDC. This property is on a corner lot, and at their property line and beyond, they have a very large planter with large trees and hedges. So when you're at the stop sign, you can't see the oncoming traffic.
Okay, yeah, thank you. All right, I'll take a look. Exhibits A and B are admitted as evidence. You took the photos on the dates indicated.
This property was posted. I was at a class, so Officer Nocella posted the property and took the picture.
All right. Okay. Let me take a look. Have you had contact with the property, or Ms. Nocella? I don't know. Did you? Okay. Yeah, unfortunately, I'm sorry. It's. Yeah, I he is getting you into trouble. So, can you swear an oath?
Yes, Jillian Nocella, Code Compliance. Yes, I posted the property with the notice of hearing. I have not had contact with anyone either.
So you took the initial photos?
No.
Or no, the posting?
Yes, only the photo posting, the
Okay.
notice at the property for hearing
Okay.
since Officer Olson was at a class that week.
Okay, all right, that's all I need to know. Thank you. All right, what's the county's recommendation?
Citrus County Code Compliance Division recommends $150 per day in addition to administrative costs.
I'm just reading the code section. Help me with the code section. What's the issue?
The hedges and such are in excess of 30 inches within the visibility triangle
Okay.
as defined by the code.
Okay, fences, walls, hedges, or other structures or vegetation shall not be permitted over 30 inches in height above the average road grade in a visibility triangle. What's the visibility triangle here?
I believe my officer brought the code section.
You want it?
Yeah.
So basically, it's 25 feet back from where the property lines intersect. So go 25 and 25 is a visibility triangle, and this is clearly in
It's
that.
depicted on page 2, I think.
Yeah, the second page of that code actually has a drawing, yes.
Okay, here we see it. All right. Okay, I think it's proven. So this is in reference to section 7180 of the LDC, I believe. And it has a graphic depiction on sub B of the clear visibility triangle. What that is, it's definitely in violation, given that definition. And what is the county's recommendation? It was
150 per day in admin costs.
All right, then I'll find the property in violation. Grant, this case is old. 15 days, $250 a day.
Thank you.
Okay.
Next case, Deneen Ritter, case number 2025-1715, Code Officer Erica Olson, page 30 of your agenda.
Erica Olson, Citrus County Code Compliance Officer. Case number 202501715, accumulation of junk and debris. The address is 5200 West Winter Sun Lane. It's 0.55 acres, zone RUR MH. This property has a lot of garbage, miscellaneous junk and debris, spare wood, car parts.
Okay. I'll take a look at the photos, and exhibits A and B will be admitted as evidence. You took the photos on the dates indicated. What is the county's recommendation?
The county recommends $200 per day plus administrative costs.
Have you had contact with the owner
No, I haven't.
or the occupant?
No, sir.
Anyone? All right, 15 days, $250 a day.
Thank you.
Thank you.
Next case, USA Ameribank, case number 2025-1714, Code Officer Erica Olson, page 36 of your agenda. Expert on the case, Joanna Coutu.
Case number CE 2025-01714, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102 Alpha. This address is 5176 West Winter Sun Lane, 0.55 acres on RUR MH. This property is next to the case I just presented.
Okay.
I believe that all the stuff that is on this property, the car parts, the tools, all the junk,
Were put there by the neighbor?
yes.
I see. This is bank-owned, like foreclosed property or something?
It's just
Okay, bank-owned. All right, you took the photos on the dates indicated?
Yes.
Have you had contact with the owner?
No, sir.
What is your recommendation?
$50 a day plus admin costs.
Wow. And this may seem like an obvious question, but why do you think it is the neighbor?
There's no fence, and with the aerial photos, I can roughly see like what would be the property lines. There's like a shed on the other property that's like right there, and everything is just kind of like a continuation.
How big is this property?
0.55.
All right, I'll do 30 days and $50 a day.
Thank you.
Last case, Young's Wholesale LLC, case number 2025-1774, Code Officer Cody McGuire, page 39 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer, case number 2025-1774, excessive growth and accumulation of vegetation, violation of Chapter 20, Article 6, 20-61 of the Citrus County Code of Ordinances. The address is 589 North Palm Ridge Avenue in Crystal River. It is 0.16 acres and it is zoned LDRMH. The property owner is Young's Wholesale LLC. And then I have signed certified mail return receipt. This is just a vacant property that we had previous other violations on before, but since the home has been demolished and they have not maintained the property.
Are they recent code enforcement cases? Was it demolished pursuant to being blight or slum?
I believe so.
Wow, okay.
It did catch on fire, I know, at one point. I don't remember what Mr. Young had spoken to me, though, about it.
You did have contact with
I
Young?
did. He said that he was doing like a rent-to-own to a woman and that he was going to get a hold of her, and it never happened. I've tried to make contact with him several times and left him messages, and I still haven't heard back from him.
Okay, exhibits A and B are admitted as evidence. You took the photos on the dates indicated, I assume. What is your recommendation?
$200 a day.
All right. There's been prior cases with the same owner?
With Mr. Young, yeah.
7 days, $350 a day.
Thank you.
Thank you. Is there anything else that we need to take up today? Okay. Time is 12:25. This hearing is adjourned.